like to call the General Laws and Technology Committee to order, please, if you call the roll.
Senator Bell.
I am online.
Madam Chair, you have a quorum.
Thank you very much. Let me first acknowledge that I am not George Barker,
Thank God.
but I do know a little bit about running this committee. So let us get started with the subcommittee report from gaming.
Thank you, Madam Chair. So starting off, we had a number of bills in subcommittee, which we heard. Sorry, we're just pausing for. All right, thank you, Madam Chair. We had a number of bills up in subcommittee that we considered. We're going to, if it's okay with you, Madam Chair, take up the one bill from Senator Norman, then a block of bills related to charitable gaming, and then take up casino-related as a matter of order that we can sort of logically take up, not necessarily by a bill number, but by subject matter. The first was Senate Bill 96, patroned by Senator Norman. This is a bill that would prohibit the use of the phrase in its amended form and would move the amendment to the committee. If I get a second.
Second.
This is, Madam Chair, so
It's
motion.
been moved and seconded that, what are we doing, Senate Bill 96?
The amendment.
The amendment, all in favor, please say aye.
Aye.
Those opposed? The amendment is,
Thank you, Madam Chair. So the amendment now would ban the use of the phrase "Virginia is for betters," Madam Chair, and that is the bill. It's recommended to report 8-0, and so move.
It's a really good bill, you don't have to gamble on it.
okay, was that to PBI, the bill?
Yes, second.
I'm throwing a bet on that one.
Okay. It's been moved and seconded that Senate Bill 96 be reported. All those in favor, please vote.
Senator Bell, how do you vote?
Aye.
Ayes 13, no 0.
Ayes 13, no 0. That bill is reported.
Thank you, Madam Chair. The next bill up, I'll invite, we're going to have sort of a dynamic interaction of both Senator Reeves as well as Senator Bell. The first up is Senate Bill 366, dealing with horse racing and pari-mutuel betting. This bill raises the age from 18 to 21 for actually pulling a lever on the machines, as I understand it, Senator Reeves, but would not prohibit 18-year-olds from betting on the ponies themselves. You want to clarify, Senator Reeves? And there's a substitute to be adopted, and would so move the substitute.
Madam Chair, I would second the move for the substitute.
Moved and seconded that the substitute be adopted. All those in favor, please say aye.
Aye.
Those opposed? The substitute's adopted.
Thank you, Mr. Chairman. Madam Chair, now Mr. Chairman. The substitute, the original bill is drawn to make both 21. In consultation with others in other states and how they do it, you can now bet on the ponies at 18, but you have to be 21 to pull a slot machine, and that's what the bill does, Mr. Chairman.
Mr. Chairman, the subcommittee recommended reporting the substitute at 8-0, and I'm not sure also if there's notes on which ones need to go to finance. So if the clerk can identify or flag or waive.
This one does, it says that we do have to go to.
Move to report and refer to finance.
Second.
All right, any further discussion on the bill? All right. Get your mic. We'll vote now. How do I vote?
Senator Bell, how do you vote?
Aye.
Ayes 14, no 0.
All right, That one will be reported and re-referred to Finance.
Thank you, Mr. Chair. The next bill that the subcommittee considered was Senate Bill 394, patroned by Senator Bell, dealing with Texas Hold'em games and poker operations, and I'll let Senator Bell briefly cover the bill. It was a recommended report of 8-0. Senator Bell.
Thank you, Mr. Chairman. We'll say that we have, I believe there's 5 bills here, and then there's another one that will got SB 399. Which unfortunately was referred to Judiciary, will be coming back to this committee. All of those are the output of the study we did on charitable gaming over the off season. Myself and Senator Reeves worked very closely with Delegate Krezak and chaired this bicameral bipartisan committee to look at this. We had a number of witnesses and stakeholders who came in, and frankly, we found a number of things that were disturbing. And we've addressed these through different bills. We also have the OISG report, which gave specific recommendations and is at the heart of many of the things we're doing in the bills. As we go forward, I think we'll probably tag team, if that's all right, on these, Mr. Chairman. We'll say if there's a hard question, ask Senator Reeves. It's easy. I'll answer it.
All right. Are there any questions?
This one specifically, Mr. Chairman, to clarify on this one, we had some issues on Texas Hold'em. Originally, the intention was on Senator Peterson's bill was to grant our charitable organizations the ability to do Texas Hold'em, and the idea was to help them replace declining revenue from bingo games, which have also been hit very hard through the COVID pandemic. However, the idea was to basically have those either at an organization that the charity owned or at a qualified organization. This bill seeks to have transparency, so if rent is charged, it will be known, it will be reasonable, and it goes to a specific issue that we identified in the commission. With that, I'll be happy to answer any questions that you may have.
All right. Are there questions for Senator Bell?
And with that, Mr. Chairman, it was a recommendation of the committee to report the bill 8-0.
All right. And you want to make that motion?
So moved.
And this would also have to be referred to Finance. So.
Re-refer to Finance.
Yes. All right. We have a motion and a second to report and re-refer to Finance. Any further discussion? All right. We'll vote on the bill.
Senator Bell, how do you vote?
Aye.
Ayes 15, no 0.
Thank you, Mr. Chair. The next bill the committee considered was Senate Bill 401 regarding overall enforcement and also illegal gaming laws. There was an amendment offered, and so move the amendment.
All right. We got a motion and a second to adopt that amendment. All in favor say aye.
Aye.
All opposed, no. That amendment is adopted.
Mr. Chairman, on this bill, one of the key findings we had from the commission was, frankly, we just don't have enough enforcement agents, and I think that's allowed some of the bad actors to flourish. Prior to 2008, the charitable gaming enforcement was funded by a percentage of charitable gaming revenues. After that, it was part of the general fund, and unfortunately, it's seen a pretty steady decline. In 2007, there were 31 enforcement agents. And charitable gaming at that time was about a fourth of what we believe it is today. Today we have 5. So this seeks to clarify that and to make sure we have enough resources to do the enforcement properly, and it's in line with what we found were best practices around the United States.
All right. Is there any questions for the patron on 401?
Mr. Chairman, I just asked that Senator Bell, sorry, if he could clarify also on the fee. Is this also the bill that you had an amendment for the fee collection question?
Mr. Chairman, that's correct. There was our excellent DLS staff brought up that there might have been a constitutionality issue based on the way the revenue was going. It was going to be basically collected by VDAX and then given back to charity, which is a problem. So we changed that. So basically a fee would be charged and the charity would keep their proceeds before they paid the fee to VDAX. So we clarified that. So thank you for bringing that up, Senator McPike.
And Mr. Chairman, just to clarify with council, the amendment that's adopted by the committee does handle that, correct?
Mr. Chairman, Senator McPike, the amendment from the gaming subcommittee does not
Right.
cover that.
And so we do have an amendment prepared to address that, correct?
Yes, sir.
Okay, so I'd also offer that amendment. I just want to make sure procedurally we were capturing each of the subcommittee's amendments as well as the needed amendments today. So I'd also move that amendment.
All right, we've got a motion and a second to adopt that amendment. All in favor, say aye.
Aye.
All opposed,
Aye.
no. All right, that amendment's adopted.
And with that, Mr. Chairman, the bill was recommended report 8-0. And
right.
so move and re-refer to finance.
Second.
All right, the motion to report and re-refer to finance. Any further discussion? All right, we'll vote on that motion.
Senator Bell, how do you vote?
Aye.
Ayes 15, no zero.
Thank you,
All right.
Mr. Chairman. The next bill the subcommittee considered was Senate Bill 401 regarding the charitable gaming powers of boards and duties.
We just did that one.
I'm sorry, 402.
Yeah.
So, in doing exactly what I just said. And so I'm going to pass it over to Senator Reeves to provide a brief intro to the bill. And I believe we have some amendments also to offer today, correct?
I don't think so. Thank you, Mr. Chairman. There are a couple of amendments because it couldn't be adopted in sub, but this bill is in direct response to the OSIG recommendations of conflicts of interest to take the regulatory authority away from the Charitable Gaming Board, make it an advisory board, and give that regulatory authority back to VDAX to promulgate the regulations going forward. There was a direct link between this board and some of the things that have happened. So with that, I would, if Ashley wants to bring forward the amendments, or we can just move the amendments forward. They were technical in nature.
All right. What amendments do you have? You want to
Mr.
summarize
Chairman,
them?
as Senator Reeves said, most of these amendments are technical in nature. It changes throughout the bill. Anytime it talks about VDAX promulgating regulations, it changes it from the Department of Agriculture and Consumer Services to the Commissioner. That was just a technical amendment. And the only other thing is in the last enactment clause, there was some misnumbering. So that was changed as well.
Mr. Chair,
All
so
right.
move the
How many
amendment.
amendments total are there?
A bunch.
Mr. Chairman, it's 15.
15, okay, 15 amendments here. We're going in a block?
And a block.
All right, motion is made to adopt the 15 amendments in a block. It's been seconded. If there's no further discussion, all in favor say aye.
Aye.
All opposed, no. All right, those amendments are adopted.
And Mr. Chairman, with those amendments, the subcommittee, through discussion, did have a recommendation to report on an 8-0 vote, and so move and re-refer to finance.
Second.
All right, motion to report and re-refer to finance with amendments to the bill. The motion has been seconded. If there's no further discussion, we'll vote now.
Senator Bell, how do you vote?
Aye.
Ayes 15, no zero.
All right, ayes 15, no zero.
Thank you, Mr. Chairman.
The bill will be reported and re-referred to finance.
Thank you, Mr. Chair. The next bill the Senate Committee considered was Senate Bill 403, related to charitable gaming as well as their social quarters and social organizations. We had amendments in committee, but I believe we have a substitute today, which Senator Reeves can offer and speak to.
Mr. Chairman, I would move the substitute, but I also have an amendment to the substitute. We just left out a part of the code that we need to put back in there with relation to the fees. So if we can move the substitute.
All right.
I would second that motion.
All right, we have a motion that's made and seconded for the substitute. And if there's no further discussion, all in favor say aye.
Aye.
All opposed, no. All right, that is adopted.
And then,
Senator
Mr.
Reed.
Chairman, if I could have Ashley go through the section that was inadvertently omitted. It has to do with adjusted gross fees with regard to audit fees, and that's 182340.31. Ashley, if you can say where we're going to insert that into the bill, please.
Yes, Mr. Chairman, and Senator Reeves, so 18.2-340.31 will be inserted into the bill. If you're looking at the substitute, it'd be around line 459, and that would just add language to make it clear that any report filed by a manufacturer of an electronic game is also included in the audit and administration fee. And so right now, the department charges organizations this audit and administration fee. This just expands that code section to include electronic gaming manufacturers who would pay the fee based on electronic gaming adjusted gross receipts instead of gross receipts as organizations currently pay.
All right, so the
Thank you,
motion
Ashley.
is basically to have it be for adjusted gross receipts rather than gross receipts. Is that correct?
Yes, Mr. Chairman, that is
All
correct. And I would move that amendment.
Second.
All right, as a motion has been made and a second to adopt this amendment. All in favor say aye.
Aye.
All opposed, no. All right, that amendment's adopted.
So, Mr. Chairman, with the Senate substitute with the amendments, I would like to just kind of work through the bill to explain how we got here and why dealing with social quarters is the hardest issue to deal with. And I think that as a committee, and I think Senator Bell can chime in, that we heard a lot of testimony about machines proliferating in bars and restaurants, and that was not the will of the General Assembly, and that we were trying to rein these in and keep them within the 4 boxes of what we traditionally know as our charities and fraternal organizations. In the subcommittee, we heard from Mr. Marty Williams, who represents some charitables down in his district that he was worried about would not fit into some of the other organizations, and we don't want to leave anyone out. So one of the things that we did in the substitute under lines 233 through 236 was address that concern. I think we've met that concern for you. And I'd like to read that section. It says, prescribe the conditions under which a qualified organization may lease the premises of a permitted social organization for the purpose of selling instant bingo pull tabs or seal cards or conducting electronic gaming, and establish requirements for proper financial reporting of all disbursements and gross receipts or electronic gaming adjusted gross receipts and payment of all fees required under the article. What that would allow them to do is, as Mr. Williams said, he had swim teams and, I don't know, baseball teams or something else that would like to do charitable gaming, but don't have a corporate headquarters or anything like that. What they can do is work with the Elks or the Moose Lodge or VFW or American Legions, and they can rent their locations, but that keeps them in those organizations where typical social quarters is what we defined as will stay. So that allows those organizations as well to be able to partake in charitable gaming. Okay. There's a few other sections in here where it was under discussion, but if we were to take some of the amendments that some of those folks wanted us to have, we'd be right back where we were. So, Mr. Chairman, it narrowly defines keeping our charitable gaming back where we intended, back in those main locations where they have their headquarters. It does not prevent anybody to play those electronic games. It's not 21. So we fixed that as well in there. And that's pretty much the summary of the bill, Mr. Chairman.
All right, Senator Evans.
Just a clarification for Senator Reeves. Under the substitute, if a charity wanted to have bingo, but they don't own their own bingo hall, does that allow them to rent a bingo hall from someone else in the same locality?
It does.
Okay, I just wanted to clarify that for the record. Thank you.
Mr. Chairman,
Yes, Senator Mason.
could the patron walk through the recent amendment, speaking to the gross receipts? I didn't hear that completely.
So, Mr. Chairman, Senator Mason, sure. 182340 just is the audit of reports, exemption, audit, administration fee, additional gross receipts assessment. And cooperating with a couple of the gaming manufacturers, the gross receipts would allow those organizations, they couldn't really operate. Let me just say it like that. It would be very difficult for them to be involved in charitable gaming based off those gross receipts with the amount that they make off of it. So in negotiations with them, they've provided me with intellectual knowledge of what they actually made. That's proprietary, and I'm not allowed to share that with anyone else, but I understand once they prove to me what their gross were and what their adjusted nets were. I was comfortable with that, Senator Mason, because I think businesses do have the ability to make a profit, but as well give to those charities. And so that's why we agreed to the adjusted gross receipts.
All right, any further discussion?
And with that, Mr. Chairman, the subcommittee had recommended reporting on an 8-0 vote and would move the substitute be reported and referred to finance.
All right, there's a motion
With amendment.
that the bill as amended is recommended for, would be reported and re-referred to finance.
Second.
All in favor, if there's no further discussion, all in favor say aye.
Senator Bell, how do you vote?
Aye.
Ayes 15, no zero.
All right, that bill is reported and re-referred to finance.
Thank you, Mr. Chairman. The next bill that we took up was Senate Bill 530 regarding overall enforcement and illegal gaming. And it's my understanding also for Senate Bill 566, Senator McDougall, and speaking with both, it's the preference of the patron for 530 for the language of Senate Bill 566 to be utilized in Senate Bill 530, and that Senator McDougall be rolled in and be listed as co-chief patron with Senator Reeves, and would so move.
All right, we have a motion before us with an amendment here. All in favor say aye.
Aye.
All opposed, no. All right, proceed.
Senator Reeves.
Thank you, Mr. Chairman.
Yes, that would incorporate Senator McDougall's bill. Let's also have a motion to incorporate Senator McDougall's bill and roll it in to this bill. So
And listed as chief co-patron.
Yes.
So,
Did we make a motion?
Yeah, it's a recorded.
Okay. No. Did we make a motion to roll Senator McDougall's in? I think it was discussion.
With the language from Senate Bill 566 into 530, so the language from 566 will prevail
Right.
into 530 with McDougall listed as co-chief patron.
All right.
Just to muddy it all up.
Yeah. Just want to make sure I did.
I'm taking it to the House.
Yeah. All right. So have we voted that
And so-
portion of that amendment then?
And so move.
Okay.
Second.
All right. Okay, motion and a second to roll the bills together. All in favor say aye.
Aye.
All opposed, no. Huh? Can we record it? Oh, yeah, we actually, we get to do it on the board, so this,
Senator Bell, how do you vote?
yeah.
Aye.
Ayes 15, no zero.
All right, that is done, so. All right,
Senator Reeves, you want to describe now
Yeah.
Senate Bill 530?
Yeah, absolutely. So, Mr. Chairman, 566 just strengthens the penalty that may be imposed for violations of charitable gaming law. It allows for an action for a pretrial levy or seizure of an attachment for a defendant who violates any provision of the charitable gaming law and requires the Department of State Police, it's not a may, it's a shall, to assist the Virginia Department of Agricultural Services in the conduct of investigations of charitable gaming violations. That's a summary of the bill.
all right. Are there any amendments to that bill?
We just finished those. That's what we voted on, Mr. Chairman.
Okay, all right.
Ready to report.
And with that, Mr. Chairman, it did recommend report from the subcommittee on a vote to 8-0, and so move, and
All right.
re-refer to finance.
All right, motion to report and re-refer to finance. There's no further discussion, we'll vote on the board.
Senator Bell, how do you vote?
Aye.
Ayes 15, no zero.
All right, that bill is reported and re-referred to finance. All right, next.
Mr. Chairman, we also took up Senate Bill 576 from Senator Mason, adding the provision to allow a online sports bet or sports bet operator to take and place bets on Virginia college sports. And we'll turn over and defer to Senator Mason. This is an issue that did come before this body and was endorsed in the Senate several years ago. Senator Mason.
Thank you, Mr. Chairman. And Ms. Subcommittee Chairman, yes, this was the posture of the State Senate when we passed the gaming bills last couple of years. As I said in subcommittee, you know, there are no prop bets. You'll never be a quarterback over 200 yards. It is simply who wins a game based on spread and over-under. And if there's anybody in this room that doesn't think that a single person in the Commonwealth of Virginia cast a bet on the Virginia Tech football game this year, I'd like to see you raise your hand and come to the lectern. Or VCU, keep careful, or VCU Richmond basketball game that was hotly contested this weekend. This simply puts it on a device where it's registered in my name, I have an account, it's tracked, and any monies that are collected based upon the winnings are taxed in Virginia. Quite candidly, I could care less about the additional revenue. It is all focus of driving this above ground and not keeping it behind closed doors as it has always been. Mr. Chairman, that's the bill.
All right.
And with that, Mr. Chairman, it did have a recommendation to report of a vote of 7-2.
All right, 7-2 to report there. All right, are there any questions or comments from other members of the committee? All right.
With that, Mr. Chairman, I move to report and re-refer Senate Bill 576 to re-refer to Finance. Report and re-refer to Finance.
All right. So it's a motion to report and re-refer to Finance. If there's no further discussion on the bill, we'll vote now.
Senator Bell, how do you vote?
Aye.
Oh, okay. Okay. No. All right.
There you go.
All right. Okay. All right, now.
Empire Strikes Back here.
I think Boy Scouts voted against it.
Yeah, that's what, yeah.
But they got yes up there, so that needs to be changed.
There we go.
There we go.
All right, finally.
It's just.
I don't know what we did wrong or right, but it's here.
No.
Ayes 11, noes 4.
All right.
Oh, I know which one it is.
Yeah. All right.
Next up, Mr. Chairman. It's just a few more left, all easy. Senate Bill 519, patroned by Senator Lucas. This is the bill that would provide for the ABC license provisions within casinos. And so it addressed two components, one of which is the serving of alcohol on the floor of the casinos, as well as the provisions of which the constraints of which alcohol can be given away and which it cannot. It also provides provisions for a restaurant adjacent to the casino in terms of how drinks need to be labeled in containers as they transact between the restaurant and on the floor, Mr. Chairman. We did have a substitute that would need to be adopted by the committee and would so move.
All right, have a motion to adopt a substitute. Second, all in favor say aye. All opposed,
Aye.
no. All right, that is adopted.
With that, Mr. Chairman, I defer if the patron would wish to speak, but I think we've covered the issue. This is more cleans up. We knew that this issue was going to be coming when the casino legislation passed, and we knew we would have to address some of the ABC provisions, which we had not yet captured, and have a favorable report from the subcommittee as well, Mr. Chairman, and would so moved and be reported and re-referred to Finance.
Actually, this one
With the substitute.
flagged, but this was not flagged by Finance. So.
Outstanding. Well,
All right.
I don't know what Senator Lucas did on this one, but well done. With that, I'd move to report the substitute.
All right, we have a motion to report the substitute. Vote on it now.
Senator Bell, how do you vote?
Aye.
Ruff has Reeves and Rowe.
Senator Ruff.
Yeah.
One more. Ayes 13, noes 2.
Okay. Ayes 13, no 2, that bill is reported directly to the Senate.
Senator,
Yes.
Mr. Chair.
Yes.
Next up is Senate Bill 462 regarding video game terminals, patroned by Senator Bell. Senator Bell, after presenting some parts of the bill, had indicated wishes that the bill be carried over to the 2023 session and would so move.
Second.
All right, we have a motion to carry it over to the 2023 session. And there's a second to that motion. Any further discussion? All right, let's vote on the board.
Senator Bell, how do you vote?
Aye.
Ayes 15, no 0.
All right, that is this was one of the ones, Hobie, in situations where we're carrying the bill over and finance had asked for it, is that only they don't get it? So okay, that's what I figured. So we weren't carrying it over. Okay, so I want to make sure. So yeah, all right. Next.
Mr. Chairman, next up is Senate Bill 2003, patroned by Senator Morrissey. This provision would add Petersburg to the list of cities eligible to host a casino in the Commonwealth. We had a substantial amount of discussion as well as testimony in committee. Conceptually, what this would effectively do is add a sixth eligible locality. However, we did provide in committee a constraint that it would be held to within Richmond, I believe, by amendment. And council, maybe you could help to clarify. We did have a substitute, number one, to adopt, and then I think we had an amendment to the substitute. If council can make sure we step through the appropriate procedures for this.
Yes, Mr. Chairman. So the substitute, which incorporates the ideas from subcommittee, basically makes it so that there are only a total of 5 casinos allowed. And for the current 5th casino, which that description is for the city of Richmond, we broke it out into an A and a B section. So it's 5A would be the city of Richmond and 5B would be the city of Petersburg. And we connected those by an or. So that means that it's either Petersburg or Richmond, not both, to keep it down to 5. And then in the local referendum section, we added language that basically says any host city that holds a local referendum that subsequently fails shall be prohibited from holding another one on the same question for a period of 5 years from the date of the last referendum. And that is all brought together by the second enactment clause that basically describes that for the purposes of that new section that I just read, any local referendum that was held on November 2nd, 2021 by the eligible host city described in subdivision A5, which is Richmond, shall be deemed the most recent local referendum such that such eligible host city shall be prohibited from holding another local referendum on the same question until after November 2nd, 2026.
So, Mr. Chairman, the policy considerations of the subcommittee were to, as council just laid out, and would so move the adoption of the substitute.
All right, motion to adopt the substitute that's been described. And a second to that motion. Is there any further discussion? Okay, all in favor? We'll vote on the board, so.
Say aye.
Oh, yeah, I say aye. I'm sorry. All in favor, say aye. All opposed, no. Okay, that's adopted, so.
Thank you, Mr. Chairman. And to follow up, and I know the patron is also present here with us, there was considerable discussion. There's some level of objection from representatives from the city of Richmond. We do understand that the city of Richmond is moving forward with some actions under the current law which would allow them to pursue another referendum. Right. It's now the position of the substitute that would preclude them for a period of 5 years. Likewise, it was discussed in the committee that if the referendum in Petersburg would fail, it would equally prohibit them from pursuing another referendum for a period of 5 years. And so that was some of the substantive discussion. There was discussion ensuring that the language of this bill did not expand the number of casino licenses. That's why we've adopted the substitute before us. And it's certainly before this committee to decide on the policy matters before us in regards to how to resolve some of the Petersburg or Richmond. This seems to be a place of consideration, certainly understanding that Richmond does want to pursue. This legislation would now roll that ability back for the period of 5 years.
All right. Any discussion on the bill? Yes, it would have to go to finance. So that. Okay, there's a motion to report and refer. Is there a second?
Second.
All right, we have a motion and a second. Senator Morrissey, you want to briefly say anything? Yes. Okay. All right. If there's no further discussion on the bill, we have a motion to report and re-refer to finance, and we'll vote on that.
Senator Bell, how do you vote?
Aye.
Ayes 15, no zero.
All right, 15, no zeros. That bill is reported and re-referred to finance.
Mr. Chairman, and I really hope that concludes my report.
Yes.
I just want to make sure that the clerk has everything registered that we need for you from that subcommittee docket, understanding there's one more bill, as indicated earlier, that is going to come back through the committee. But
Okay.
Mr. Chair, I'm seeking some guidance from the chair. I do not want to step in front of any of my colleagues. SB 129 is going to be before this body. I'm, as you know, also sit on judiciary at this exact
Right.
time. Can I get some guidance if you'd like to take that up now, or if I should come back?
Why don't you come back? Yeah, we've got several other bills we got to move forward on, so. All right. So, okay. Yes, there are, so. All right. Do we have a sign-up sheet as to who's next here? Okay. Oh, okay. Senator Stanley, Senator Maduro, Senator Norman.
Thank you very much, ladies and gentlemen of the committee. I have Bill 76, which Senator Locke from Hampton has a very similar bill, and out of respect for her being the primary representative of the city of Hampton and me just having a precinct or two that she was kind enough to exclude the Republicans in Hampton from her voting base, I would be happy to roll my bill into hers.
Senator Locke, do you have a motion to make? So, on Senate Bill 76.
Mr. Chairman, I would move that we roll Senate Bill 76 into Senate Bill 23.
Second.
All right, we got a motion and a second to roll Senate Bill 76 into Senate Bill 23. All right, is there any further discussion? All right, we will vote on rolling it in. So,
Senator Bell, how do you vote?
Aye.
Ayes 14, no zero.
Senator Locke?
I forgot to vote. And I will be
No
happy
respect,
to,
so.
I will be happy to have his name appear next to mine.
Okay. So record Senator Locke as having voted aye. So, and
Thank you, Mr. Chairman, and thank you, Senator Locke. And then I have Senate Bill 584, which Senator Eben has the exact same bill after I make a motion, and I am going to move that the Senate Bill 584 that I have conform to Senator Eben's bill of 393.
all right. So you want to have it conform to Senator?
Yes, sir. Is that all right, Senator Eben?
Yeah.
Okay.
Mr. Chair, I'll go ahead and make that motion.
All right. Motion and a second to have Senate Bill 584 from Senator Norman conform to Senator Eben's bill of 393.
And I would ask that you list me as a co-chief patron, if you would, please.
All right, and as we roll that in, and he will be the chief co-patron, so. All right.
Senator
There's
Evan really is the
Yeah,
leader
we-
on this bill, and it focuses, we're okay?
Yeah, we need to take the vote on that one, on the previous one there, we just discussed
Yes,
with
sir.
Senator Evans. All right, let's vote on the recommendation here, so.
Senator Bell, how do you vote?
Aye.
All right.
That's 15, no zero.
Thank you,
Yeah.
Senator Barker. Senator Eben is really the lead on this bill, as it comes out of a very significant economic development project in his community, and I'm going to let him speak on it. The only thing I would say is we previously had enacted a legislation known as Virginia Consumer Data Privacy Act, which was not going to take effect till January the 1st of 2023, so it had a delayed enactment on it. And what it deals with is having consumers given the ability to delete their data that is collected from sources other than themselves. And I will defer to Senator Eben on the balance of it.
Thank you.
All right. Senator Evans.
As the committee knows, we became the second state in the nation to pass a comprehensive privacy law that balances a consumer's right to protect their data and provide a set of consistent rules for companies that manage data to follow to comply with the law. The law largely accomplishes this goal, except for the right to delete provision. Currently, the right to delete is a gray area for both consumers and data companies. The language currently reads, delete personal data provided by or obtained about the consumer. And the tricky language is the part that says is obtained about the consumer. For companies that have a direct relation with the consumer and get data directly from the consumer, complying with this requirement is straightforward because the company gets the data directly from the consumer and they can just delete it. However, there are lots of entities that lawfully collect data about a consumer from multiple sources, including even public records, multiple times and on a reoccurring basis. So these entities don't have a direct relation with the consumer and are mostly business-to-business companies. So under current law, if a consumer requests to have their data deleted and the entity deletes the entirety of the consumer's data at that specific time, they've complied with the law. However, if the consumer's data is then picked up again following the deletion in another batch of data, the consumer is left with the hollow promise of having their data deleted. Because the entity must delete all personally identifiable data when the request to delete is made, it's impossible for them to stop recollecting and using that data again at another time. So there's no way to flag that the consumer's requested the deletion later because the entire record of the consumer is gone. So what this bill does, essentially, is it puts the consumer's data in a lockbox where it cannot be used. So when the firm does another data pickup after the consumer's request is honored, the data goes to the lockbox and they can look and see, okay, George Barker has said not to distribute his data. We've set aside his name and identifiable information and know that we're not going to repopulate the system and use it again. So this change has been circulated. It was there was a work group that I believe Senator Marsden headed this summer, and it was discussed there. That's the gist of the bill. We have a few representatives who could speak to it, but we did receive a letter from Attorney General Miyares who said this bill does provide a solution to this issue by allowing an entity to treat a deletion request as an opt-out provision. A consumer can now be confident that through their data deletion request, their data is no longer being utilized. And I have the letter from the Attorney General, but that's the key provision of it. And we do have a few representatives who can answer questions perhaps better than I can.
All right, we're going to be quick and short on public testimony today because we got so many bills, over 100 bills been sent to this committee. We're plowing through them as fast as we can, but doing well. But anyway, we're going to no more than 2 minutes total for each side. So those who want to speak in favor of the bill.
You know, I'm Mr. Ecumenical to Senator, you know that, and I appreciate the Senator emphasizing that the current Attorney General rose in support of this, but I would also, the former Attorney General agreed also, and and it's very good. That's probably the only thing that they have agreed on, so I just want to share that with you.
Good point.
Yeah. All right, those in favor of the bill, come forward. We're going to start the timer now at 2 minutes, so.
Mr. Chairman and members of the committee, David Skiles with the Vector Corporation representing Reed Elsevier. I want to thank Senator Norman and Senator Eben for bringing this bill forward. Obviously, this solves an important issue. It's something that has been looked at extensively, and I think there's pretty broad consensus needs to be addressed. This bill does that, so appreciate the committee's support. Happy to answer any questions.
All right. Anybody else wish to speak in favor of the bill?
If you are in the Zoom room and wish to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. Is there anyone who wishes to speak in opposition to the bill? All right.
If you are in the Zoom room and you wish to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, we have one speaker.
All right.
Maureen Mahomey, please unmute and begin your testimony.
Thank you. Chair, members of the committee, thank you for the opportunity to speak today. My name is Maureen Mahoney. I'm a senior policy analyst at Consumer Reports, and I'm speaking in respectful opposition to this bill. I appreciate that the goals of the bill are to prevent deleted data from reappearing in data brokers' systems, but I think the appropriate way to deal with it is not by taking deletion rights away, but by clarifying that the data needs to stay deleted, perhaps by retaining a record of the deletion request. The reason why data brokers shouldn't be allowed to ignore deletion requests is because it's a major security risk. This data is often breached. For example, LexisNexis, a Relic subsidiary, was hacked nearly 60 times in 2005, implicating social security numbers and driver's license information of hundreds of thousands of people. There are also uses of that data that aren't covered by the opt-out. For example, data brokers sharing location data to government entities for purposes that consumers don't know about, of which there are documented cases. I'd welcome the opportunity to discuss further, and thank you for your time.
All right. Thank you. Anybody else to speak in opposition? All right, the bill is before us.
Mr. Chairman?
Yes.
I just have the question for the patrons.
Sure.
The speaker in opposition brought up a plausible point. Why not have a do not call, do not data list that the person simply says, Adam Eben wishes to not retain data?
Well, it's for all companies, that,
To
right?
resolve the issue. I mean,
Yeah, it sounds like that would require a state agency or a state list. We didn't contemplate setting that up. We want to let you notify a company not to use your data, which was the way the bill was originally passed last year.
Yes. Senator Stewart.
I'm sorry. I think, Senator Eben, what Senator McPike was asking is if you have a lockbox for the data, why can't you just have delete all data in the lockbox with no data? I think that's what,
Okay,
I think that's what the lady said.
So you're
on the
saying
screen.
you'd like to just retain the name and
delete all data.
I'm going to ask Mr. Skiles to say what he
That
thinks
makes
of that
sense
approach.
to me. I'm just curious why we wouldn't do it that way.
Mr. Chairman and members of Senator Stewart, to answer your question, I think it'd be a bit more nuanced than that. As the speaker in opposition noted, she spoke a lot about data breaches. This bill really has nothing to do with data breaches, and while that's certainly an issue, the General Assembly passed a piece of legislation on that several years ago, and like all other technology
Mr.
companies.
Chairman.
Yes, Senator
But,
Stewart.
Mr. Chairman, it is an issue in this bill, because if you retain people's data, it is therefore in the cloud somewhere and subject to being skyjacked or whatever they do to it. And if the consumer wants their data deleted, I'm really just asking a simple question. I thought she made a good point. If you can put in the lockbox that keep their data and say, but don't release it, why can't you put in the lockbox, Stewart wants all data deleted here ever after? Why can't you do it that way?
Mr. Chairman and Senator Stewart, I would respond, and I certainly understand that the data breach is the issue here, but there is a separate statute that deals with that issue. So setting that aside, to your question about the list, as these companies go out and sweep for information often, if we were simply to have an opt-out list, like a do not call registry, if that's what Senator McPike was talking about, the issue is when we go out and pick that data back up, we don't know that it hasn't been picked up previously. And so by putting it in the lockbox, we're sure that that information isn't going to be released to the public, and we're going to comply with what the consumer wants.
Maybe explain what
All right, any further questions or comments from members of the committee? All right. Yeah. All right, we have a motion and a second to report the bill.
Mr. Chairman?
Yes.
I'm sorry. I'm sorry to be a pain.
That's all right.
But would the patrons consider it a friendly amendment if we did what the lady suggested on the screen? And as I understand this, it's not a list, it's a lockbox that these companies somehow keep or have access to. I think it makes more sense to delete the data, but have the person's name and say they want the data deleted. Is that possible? Or maybe y'all aren't interested, but it seems like to me a better way to do it.
Senator Stewart, you know from working with me that I'm an IT idiot and I haven't improved any.
Me too.
What I would encourage the committee to do is to consider go ahead and reporting the bill. We will work on an amendment with the consumer report, and then there's one other group that has an interest. We'll work on it as it's moving through, and I represent to you, we will work on that amendment.
Okay. Yeah. All right. Anybody want to address anything else? All right, we have a motion and a second to report the bill and offer to have an amendment drafted, and council here has already indicated they can do that, so that should not be a problem there. So if there's no further discussion, let's vote.
Senator Bell, how do you vote?
Aye.
Ayes 14, no zero, one abstention.
All right, ayes 14, no zero, one abstention. All right, thank you. Yeah, let's do those. Yeah. All right. We have a few bills that patrons have asked to be passed by for the day. So if we can just have an indication of which bills those are, then we can proceed along and not have anyone waiting to testify on something that we know is not going to be heard today.
Mr. Chair, those bills are Senator Peterson, Senate Bill 210.
Okay.
And Senator Evans, Senate Bill 284.
All right. Is that it? Just those two?
Yes, sir. That is all.
All right. Is there a motion to pass by for the day Senate Bills 210 and 284? All right. We have a motion. Is there a second? Second. All right. All in favor say aye. Aye. All opposed, no. All right. Those are taken care of. Senator Lucas, you're next, and then we may get around to Senator Stanley at some point, but yes, I understand. So.
Thank you, Mr. Chairman. Mr. Chairman, this is Senate Bill 661, and what the bill does, it requires the Board of Workforce Development to review the apprenticeship program performance in meeting high-demand industry needs and make recommendations to the Governor and General Assembly by December the 1st for improving performance and creating a primary office for apprenticeship programs. It requires that the department to use data from the newly created Office of Education and Labor Market Alignment in developing apprenticeship programs that are based in high-demand industry needs. Mr. President and Mr. Chairman. Mr. Chairman and members of the committee, I speak from experience when I tell you that apprenticeship programs offer an earn-as-you-learn model that provides a pathway to family-sustaining wages, on-the-job training, and mentors while reducing the need to take on student loans. And I speak from experience because I was in an apprenticeship program at the Norfolk Naval Shipyard as a ship fitter, so I know of which I speak. At the time, job creators get the opportunity to participate in the cultivation of a skilled workforce that is equipped to address the needs of today's economy. In short, apprenticeship programs are a win-win. Apprenticeships are the industry-driven, high-quality career pathways in which workers can obtain paid workforce and classroom instructions and transferable credentials from while job creators develop and prepare their future workforce. And Mr. Chairman and members of the committee, I got about 6 pages if you'd like to share all of that. Or I can,
Then again, I would just,
or in the interest of time, I can stop right there and let you deliberate.
all right, that sounds fine. All right, we will take public testimony now on this bill. Do 2 minutes for each side. So all in favor, who want to speak in favor of the bill, come forward.
Mr. Chairman, I have experts, representative from the Virginia Community College System.
All right, they're behind you, so
Oh, there he is. Okay.
proceed, so.
Mr. Chairman, thank you for letting me speak. Jason Parker, Virginia State Building Construction Trades Council. Like she said, earn as you learn, life-changing. We need a strong, and we're one of those high-need industries in the building trade, so we need a strong pipeline, not only from the education system, but from the public at large, and we definitely support this. Thank you.
All right.
If
Is
you
there
are in
anyone
the-
else to speak in favor of the bill?
If you are in the Zoom room and wish to speak in favor of this bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Ms. Sherry Neal.
All right. I think the patron knows that person.
Yes, she's a liaison for the city of Portsmouth. She's going to be in favor.
Ms. Neal, please unmute and begin your testimony. Ms. Neal, you can unmute and begin your testimony.
Thank you. Thank you, Senator Barker, the chair, and members of the committee. And I believe Senator Lucas already said what I was going to say. As the Intergovernmental Affairs Manager for the City of Portsmouth, we are strongly in support of this bill, and we thank Senator Lucas for bringing it forward. We hope that you will favorably pass it through. Thank you.
All right, thank you. Anybody else to speak in favor? All right, is there anyone who wishes to speak in opposition to the bill?
If you are in the Zoom room and wish to speak in opposition
Senator
to this
Stanley
bill,
behind you.
Oh, he's in favor.
All right.
if you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
Second.
Wait a second. This goes to finance, so we have a motion to report and refer to finance. Is there a second? Second. All right, we will vote on the board, so thank you.
Senator Bell, how do you vote?
Aye.
Ayes 15, no 0.
Mr.
All right,
Chairman and members of the committee, I thank you kindly.
Certainly. All right, we have Senator Edwards next, and then Senator Favola, and then Senator Stanley. So,
Mr. Chairman, members of the committee, Senate Bill 309 is a consumer protection bill, and I'll just very simple bill. It does the following: using any provision in any contract or written agreement that restricts a consumer's right to file a civil action to resolve a dispute that arises in connection with a consumer transaction that does not involve interstate commerce is outlawed. Any such provision should be void and unenforceable. Let me give you background. This came up as a result of a friend of mine in Roanoke, Bob Birch, a retired lawyer. He has a house in Smith Mountain Lake and was severely damaged. So he went to Lowe's to have materials installed and fix it up. And in the process, about $18,000 worth of stuff. And so in the process, they stamped on his this printout of his credit card. They stamped on their arbitration clause. And he looked into it, and sure enough, they have an arbitration clause at Lowe's that's pretty broad. It just simply says anything that any dispute, I'll read it, notice of arbitration agreement. This contract provides that all claims by customer or Lowe's will be resolved by binding arbitration. Consumer and Lowe's give up the right to go to court to enforce the contract, except in small claims court. And it goes on and on, waiver of trial by jury, waiver of class action, and so forth. It turns out there's a federal law involving this, and the solution would be, in a bill in Congress, to pass the federal law. But meanwhile, if you go to Lowe's or certain large companies like that and it involves interstate commerce, you can't sue them. You're stuck with arbitration. I don't know how many people are involved with arbitration. I've done it a couple of times. You never, ever want to get involved in arbitration.
Yeah.
I assure you. Any lawyer, there's a lawyer, a friend of mine in Roanoke, who said anybody in his firm that agreed to arbitration, you'd fire him instantly. You never, ever want to get involved in arbitration. But the people who have a consumer, it's strictly limited to consumer transactions. If you have a dispute, you ought to be able to go to court. It's that simple. Now, I know there's some people that are opposing it, but keep in mind this is for interstate commerce. Now, it may be hard to understand what is interstate commerce, but there are cases out there that can tell you what is interstate commerce. If you go to Lowe's and you buy something and they won't fix it, is Bob Birch's situation. It was almost 3 years ago when he went to see them, and they still haven't done anything. He's still mad as the dickens. And they're saying, you got to go to North Carolina, et cetera, et cetera. And he said, I can't afford to do all this for $18,000 or whatever it is. And so this idea is to protect consumers. You ought to have a right if you go to Lowe's or somebody that's J.C. Penney's, if they're still around, or someplace like that, and buy something, and you have a dispute, you ought to go to court. If you have a dispute, they shouldn't just say, I'm sorry, you cannot have arbitration. If they do, you ought to at least go to state court and show that it's not involving interstate commerce. That's a simple bill.
All right. Yes, Senator Eben.
Edwards, just to be clear, the way I read the bill, it says this is just dealing with transactions that do not involve interstate commerce, so within Virginia, right?
Correct.
Okay, that's why I want to make sure I understood properly.
And I think some of the people may be opposing it. They're talking about interstate commerce. That's my understanding.
All right. Is there any other comments or questions for the patron? All right. We will take testimony now. Anybody who wishes to speak in favor of the bill, come forward.
If you are in the Zoom room and wish to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. Then we will have people who are in opposition to the bill. So.
Good afternoon, Mr. Chairman. Ann Gambardella with the Virginia Auto Dealers Association. Our concerns with this bill is that it lacks some clarity for our members who do have many things in their contracts. This is not limited to arbitration, the language of the bill. It could involve a mediation clause. It could involve a right to cure provision, a notice provision to cure a problem. All of those things could be swept up in this, and the real problem here is that, yes, it is limited to issues and transactions that are not in interstate commerce. The Supreme Court has taken a very broad view of what interstate commerce is. So basically, you could find yourself in a situation where you are litigating whether something's in interstate commerce for every single provision of your contract. And so that's where it gets very complicated. The Supreme Court has taken a very expansive view of what interstate commerce involves. It's not simply that it was a Virginia business selling to a Virginia resident, where the materials came from, how the consumer good was assembled, and all of those things can figure into whether it was interstate commerce. And so we're just concerned about having to litigate that aspect on various provisions of our contracts for vehicle sales in Virginia.
All right. Anybody else wishing to speak in opposition to the bill?
If you are in the Zoom room and wish to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. The bill is before us.
Mr. Chairman.
Yes, Senator Edwards.
This is not intended to deal with auto dealers. I mean, they're pretty good in the way they do things because most of that is interstate commerce. And I'd be happy if somebody wants to give me some kind of an amendment, and I haven't seen any amendment to narrow it more closely, but I just haven't seen anything. So
all right.
I'm open to suggestions.
Well, Senator Edwards has indicated openness to receiving amendments from someone who might wish to narrow the parameters of this bill a little bit.
Well, like I say, I haven't seen anything
Yeah.
at this point. I'm not
All
sure
right.
where to go, but
Is there, okay, is there, yeah, there's a motion to report. Is there a second? Yeah, we got a second, yeah. All right, if there's no further discussion, we'll vote on the bill now.
Senator Bell, how do you vote?
Aye.
Ayes 8, no 7.
All right, ayes 8, no 7.
Thank you, Mr.
Motion
Chairman.
passes.
Appreciate it.
The report. All right, Senator Favola and then Senator Stanley.
Good afternoon, Mr. Chairman, members of the committee. I will be very quick. On Senate Bill 43, I would like to strike that bill. It's the Virginia Landlord Tenant, the City and County Enforcement, Senate Bill 43.
All right, we have a motion to strike Senate Bill 43.
Second.
All right, there's a motion and a second to strike the bill. We vote on the board.
Senator Bell, how do you vote?
Aye.
Ayes 15, no 0.
All right, Senator Favola.
Okay, let's move to Senate Bill 69. That's the landlord-tenant prohibited provisions and rental agreements. I do have an amendment, and I would request that the committee adopt the amendment. It's 3 lines.
All right, we have a motion to adopt an amendment, 3-line amendment to the bill. Is there a second? Yeah, there's a second now. All in favor, say aye. All opposed, no. All right, that's before adopted. So.
Okay, thank you, Mr. Chairman. I'll explain the amendment, which will essentially be the bill. What this amendment does is it merely states that a rental agreement may allow for the operation of child care services provided by a tenant of an apartment building as long as state and local laws and regulations are met, and provided that the service is only available to other residents of the apartment building. So this is permissive. We wanted to get it on the books with the hopes that landlords would actually, or be advised by their counselors that this is something they should think about and perhaps figure out how to do. There is as you know, a dearth of child care opportunities throughout Northern Virginia, probably in other parts of the state as well, and we are having a growing number of families with young children in apartment buildings, and they don't have access to child care. This is agreed to now by AOBA, and we've had many hours of negotiation, so I respectfully ask that the bill pass, and then I have another related request.
All right, just quickly, a question for you. Can you explain clearly what the amendment did that I assume is replacing lines 32 and 33 on the introduced bill?
My earlier bill actually was a flat-out, I'd say, mandate. In other words, it prohibited an exclusion of child care services. So landlords could not prohibit child care services. Right. That was not acceptable to AOBA. I tried to qualify it in many ways, but the prohibition was not acceptable, which is why I had to move to something that is permissive. They gave me several reasons, but the only way we could get to agreement was through this permissive language, which is what's in front of you.
Permissive language basically says what? I mean,
the language says may, a rental agreement may contain provisions that allow for the operation of child care services, and then it goes on to say the services, have to meet state and local regulation and only be available to residents within the building, because that addresses some of the security issues. Apartment managers did not want outside folks coming into the building, so they were and I understand that, that's legitimate. They were pretty adamant they wanted the service to be contained to those living in the building.
All right. Senator Evan.
Yeah, just for counsel, this bill would not prohibit a landlord from allowing operation of child care services for kids who are not in the building if they wanted to, does it? If they wanted to voluntarily agree, an individual landlord?
Thank you, Mr. Chairman. And Senator Eben, to your question, this bill does not prohibit anything. It doesn't, does not prohibit anything in the substitute.
It doesn't prohibit, but it doesn't mandate.
Yes.
Thank you. Yeah, no, I see there's no mandate. Okay, thank you.
You've taught me not to get between these private agreements.
All right, is there anyone that wishes to speak in favor of the bill?
Yes, Mr. Chairman, members of the committee, my name is Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We thank the Senator greatly for working with us, and we hope that you support the bill.
All right, thank you. Anyone else to speak in favor?
If you are in the Zoom room and wish to speak in support of the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right, anyone wish to speak in opposition to the bill?
If you are in the Zoom room and wish to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
As amended.
All right, we have a motion to report as amended. Is there a second? All right, a second to that motion. If there's no further discussion, we'll vote now.
Senator Bell, how do you vote?
Aye.
Ayes 15, no 0.
All right. The motion is adopted 15-0. So
Okay, great. Thank you. Thank you, Mr. Chairman. I have another very straightforward bill, Senate Bill 13. Energy performance contracts. What this bill does is it enables project managers who are putting in new roofs, usually they're solar-ready roofs or they're energy-efficient roofs, to actually use a contractor who's not necessarily listed on the state's preferred list of contractors. So it expands the pool of contractors who can be hired. We feel that this will facilitate projects, certainly with the cost of materials and some of the supply chain delay issues. This bill would be a welcome addition. And we've worked very hard with the Virginia Energy Council and many other stakeholders, but I don't think you want to hear from all of them.
all right.
Thank you, Senator.
Can staff go over what the substitute has here? And okay.
This was actually heard in Agriculture and Natural Resources, and there was only one abstention. It was voted out, but there was a determination made that this committee was more familiar with the energy contracting.
Yes.
I'm on that committee.
All right. All right. Is there anybody has questions of the patron? All right. Then we'll take public testimony. Anybody in favor, come forward.
Good afternoon, Mr. Chairman and members of the committee. My name is Chelsea Harnish. I'm the Executive Director of the Virginia Energy Efficiency Council. We appreciate Senator Vivola bringing this bill on behalf of our members who are energy service companies. They do energy performance contracting on local buildings. Energy performance contracted is a program that is run by the Virginia Department of Energy. And right now there is a exemption from doing full roof replacements, which could be needed for a variety of issues, which could be a leaking roof. It could be to make it solar ready. So this bill, in working with other stakeholders, allows full roof replacements to be included as part of a performance contract. Thank you.
All right. Next.
Mr. Chairman, members of the committee, Preston Bryan on behalf of Schneider Electric and Energy Service Company. We worked for several months on this with other contractors and such, and procurement advocates are also in favor of this. So we appreciate Senator Vivola for
Thank you.
Mr. Chairman, members of the committee, my name is Scott Schoffelbarger. I'm here on behalf of the Virginia Association of Roofing Professionals and the International Institute of Building and Blue Consultants. We're in favor of the bill and very much appreciate Mr. Bryan's efforts, a very collegial and collaborative way to incorporate our concerns into the bill. So thank you.
All right, thank you. Anybody online?
If you are in the Zoom room and wish to speak in support of this bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Connor Kish.
All right, have that speaker.
Mr. Kish, please unmute and begin your testimony.
Thank you, Mr. Chairman, members of the committee. Connor Kish with the Sierra Club Virginia chapter, and we support the bill. Thank you.
All right, thank you. Is there anyone who wishes to speak in opposition?
If you are in the Zoom room and wish to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right, we got a motion to report and a second. If there's no further discussion, we'll vote now.
Senator Bell, how do you vote?
Aye.
Ayes 14, noes 1.
All right, ayes 14, noes 1. The bill's reported.
Thank you, Mr. Chairman.
All right. Senator Stanley, I can't find anybody else, so.
I love you too.
Yeah.
I love you too, Mr. Chairman. Mr. Chairman, members of the committee, Senate Bill 712 is before you, and basically what this does is we're trying to actually play catch up with innovation, technology, and regulations and the regulatory process. I think most of us have seen that in Virginia, when we have some innovation, sometimes they call it 17 years from the innovation to actual application. And what we're trying to do is curb that. There's a number of approaches that we've kind of looked at here, and this one creates the Virginia Department of Regulatory Innovation. There are also bills with regard to these these innovation sandboxes. I keep calling it the innovation cat box. I need to correct myself because some people, there's a big difference between a sandbox and a cat box. I was just told back here. Some bills that we have are focusing on healthcare innovation in a sandbox regulatory scheme. Other bills that are being offered will address financial technologies. But basically, what we've got here is a regulatory sandbox. Those sandboxes are programs that permit innovative companies to request a temporary waiver from outdated rules and regulations that would inhibit innovation and innovation opportunities that exist in a marketplace. With ample protections in place, which is what this department aims to do, these then allow for protections to be put into the test market, allow for proper oversight from regulators, and from these tests to see if these innovations can work, and then build regulations around them. They provide data, evidence, and guidance for us, the lawmakers, to adjust the Code of Virginia. So our regulatory environment here in the Commonwealth is in tune with how modern technology is used in the marketplace. So many times we have found ourselves as legislators catching up to technology, catching up to innovation. This will allow us to get ahead of it and do so in a regulatory way, in a proper way by the sandbox, so that what we're doing is we're having all of our agencies talking to each other, working with each other in certain very controlled environments to see if we have something that's innovative and can be brought to market in a quick manner and a safe manner, then we shouldn't hold it down with all of what those burdens in the regulatory structure and scheme does for us. So this bill in its specifics, Mr. Chairman, members of the committee, basically, as I've said, creates the Department of Regulatory Innovation. It's headed by a director appointed by the governor. The bill itself, 712, if you go through it, demonstrates, of course, then the duties of the department are to administer the provisions, of course, of this act as a liaison between private businesses and applicable agencies to identify state laws or regulations that could potentially be waived or suspended under these trial programs. Basically, also, it has the ability to review state laws and regulations that may inhibit innovation and or inhibit the creation of new businesses and frameworks and industries, and then provide recommendations to the governor and to us in the General Assembly on modifying any state law that would fit with these innovations. This department can create frameworks for analyzing the risk level to the health, safety, and financial well-being of consumers related to permanently removing or temporarily waiving certain laws or regulations that may be inhibiting the creation or success of new and existing businesses or industries. It can propose potential reciprocity agreements between states that have these kind of regulatory sandboxes or these innovation sandboxes. And Mr. Chairman, members of the committee, North Carolina is doing this, West Virginia is doing this, and I don't think that we should be left behind. They can recommend rules, make administrative adjustments in the program, create advisory committees in those industries, those specific industries that can help us figure out how we can create regulations that encourage innovation and not inhibit innovation. You also see in Article 2, the administration is how you administer the Virginia Regulatory Sandbox Program, how those industries would apply to become a part of this sandbox process if there's an innovation that can be brought to the market without having overburdensome regulations preventing that innovation from being brought to the market, and even methodologies of how you review the applications, and if those applications by the department are accepted, what the participation requirements are, and also consumer protections that are also included as well. And in the end, no matter what, this department then has to report to us by October of every year to demonstrate to us exactly what's going on, what's working, what's not working, and what recommendations it may have for us legislators to make some adjustments in the code of law to stay in front of technology and innovation and stay ahead of other states, and that we're bringing in the best and the brightest in the workforce and also in new industries that will employ our citizens. And that's the bill, I think.
All right.
Oh, there's an amendment, by the way.
Yeah, I missed some of it.
Sure. Yeah, absolutely. Let me start over. So you get a box, and you get like the sand, and you put the sand in the box, and then you spread the sand. The amendment, I think, is a limitation in terms of licensing practices in the medical field, that nothing that we're doing here would allow that to occur. Is that correct?
That is correct.
I'm smart, kind of.
Not really.
No? That's on film, you know. I know you know that. Yeah. Did you want to tell them what it is? Because I can't.
Yeah, it should be posted online, but what you just said is essentially what the line amendment does. It just says nothing in this chapter shall be construed as creating any relationship otherwise protected by laws or regulations of professions that are regulated in Virginia, and also can't be construed as waiving the licensure, certification, and registration requirements.
There you go. Senator Barker, you and I have done a lot of innovative things and had a lot of great things for businesses and employees and the like. I can't wait till you sign on as chief co-patron of this bill.
My pleasure. So we have the amendment. Anybody want? Okay. There's a motion to adopt the amendment. Is there a second?
Second.
All right. All in favor say aye.
Aye.
All opposed, no. That amendment is adopted. And with that, Senator Evan.
I just want to try and clarify. So this is to create a bureaucratic agency that would seek to suspend state laws, regulations, and licensing for specific projects. Is that right?
Mr. Chairman, this is big government stopping big government and turning it back into small government. Yes.
If I could follow up, Mr. Chair.
I think it's actually bigger government stopping big government. So
from becoming bigger government?
That's right.
Okay, if that works.
Just to follow up, could you give me an example of like maybe a company or a project or something that this would have benefited? I'm trying to understand who wants to be exempted from the different regulations or who would.
As a matter of fact, I can. And it's not what would benefit, it's what has benefited. And we've seen it in the explosion of COVID and the COVID crisis. Mr. Chairman and Senator Eben, I know you're a big supporter of telemedicine, telehealth. What we saw was a lot of innovation going on in telemedicine and telehealth, but not being utilized at the time until the need and the explosion with COVID and the overburdening of our healthcare system arrived. And so what we saw was the adoption and use of COVID from 11% of U.S. consumers rising up to 46% in 2020. And it's because a lot of the regulatory process was not in place that would have inhibited that innovation. And because of the good that telemedicine and telehealth did, what we saw was because government didn't slow it down, that it actually enabled telemedicine, telehealth, telemental health to grow, but help people. And had we had an overburdensome regulatory process in place, then we couldn't have brought that medical assistance to people who really needed it in the underserved and underprivileged areas.
All right. Any further discussion? Any questions on of the patron?
Mr. Chair.
Yes. Senator Hashmi.
Thank you, Mr. Chair. Senator Stanley, I certainly appreciate the desire for innovation and the desire to speed things along. I'm curious, however, if we are moving to create DRI, what is the impact then on other agencies such as VDH or DEQ in terms of their capacity to have input and to regulate some of the changes that might emerge within this sandbox? Would they just be reduced to being consultants, or will they continue to have some kind of regulatory authority?
Mr. Chairman, I'd answer the gentlelady by saying none of their authority changes in any of this. What this really does is kind of bring together these agencies, which I think, Senator Hashmi, you would agree, we'd all agree, don't communicate with each other in the way that they need to. It also says, okay, here we have an innovation technology, something in an industry. It looks good. What do you guys think? This is a collaborative effort. This department isn't overtaking anything. What it's creating is almost the connections between our different agencies that have different responsibilities that sometimes overlap but don't communicate with each other, to ensure and to encourage collaboration so that in the innovation space that one agency might have part of and another agency may have some regulatory authority over the next, that they're coming together with this department to say, hey, is there something we could do to see if this works? Maybe relax some regulatory, some regulations that might help this grow and be successful. And then with the department, as you notice, what they're basically trying to do is they are reviewing these things and creating a framework for risk analysis, consumer protections, and working with our agencies, not instead of our agencies.
All right. Any further questions for the patron?
Mr. Chair, just a follow-up.
Sure. Senator Hashmi.
So would any part of the application of the sandbox, could it be made exempt from public disclosure? Are there regulations that we continue to have transparency in the process? Who is regulating the regulating sandbox?
Who's regulating the regulating sandbox? Mr. Chairman and Senator Hashmi had answered the gentlelady by saying, really, sometimes everything I see in here is transparent. I don't see that kind of hide the ball kind of stuff. So I would think, one, that transparency would be there. I don't think that's meant to create kind of because what my concern would be is in an industry there may be different components or people doing the same things. What we don't want to be as a government creating some kind of masking of what they're doing in order to increase innovation, but at the same time give an advantage over one company over another in the same industry.
Mr. Chairman?
Yes, Senator
Is that
Bell.
you, God?
I am out here. And following up on your remark about transparency, which I know you want, I'm a little bit concerned reading about the fiscal impact statement. It says, as written, the size and scope of the new department and staffing needs are unknown. Can you elaborate on that?
Mr. Chairman, I'm not permitted to elaborate on that because it would be transparent. I read fiscal impacts. It says indeterminate amount. You obviously, when you create a department, you create some cost, but certainly I don't have an answer for my good friend Senator Bell. So I hope that answers his question by not answering his question.
Mr. Chairman, it's an excellent non-answer of a question. Mr. Chairman, follow up, if I could, please.
Certainly, Senator Bell.
Also, the revenue that would be collected, where's that going to go? Because that's not addressed either. Can you speak to that? Is the idea to help fund the program with the revenue? Just put in the general fund to offset? Any thoughts on that?
Yeah. Mr. Chairman, I'd answer the gentleman by saying that I've been told that it tends to regurgitate itself, go back into the program, so that it fosters more economic development and innovation and actually cost to the department. And now I can see from the TV behind me that there's somebody behind me with the hands in there. So I'm going to let him answer.
You're right.
Because otherwise he's going to whisper in my ear.
There's been about 20 sandboxes across the country that have been done. The most expensive one in the country was in Utah, it mirrors this one. It was $300,000 total. And the second year it actually went down below that. It's basically two people that are a liaison between the agencies so that they can hear and listen to them so they can sign off or deny an application on safety grounds. And it's basically it.
All right, thank you. Yes, Senator Stewart.
Thank you, Mr. Chairman. I was dazzled by this technical explanation of Senator Stanley. It's a really well-written bill. It's a good bill. Obvious to me he did not write it, but I'm glad he could tell us.
Is it that obvious?
But I want you to explain it to me because I'm just a simple person. It appears to me that this bill really does nothing more than provide the ability for people who may have a good idea or bad idea to apply to try to get some relief from all the bureaucracy that businesses and others suffer from. And the agencies that would typically regulate them would be involved in looking at these, and they simply would make a decision as to whether or not it was a viable idea that was safe and should be pursued, and they may or may not give them any relief from regulations to help them move it forward. And in fact, they may say, we think it's a bad idea and you can't do that. So it really is just a bill to help innovators, to help consumers and citizens and such as that. Is it as simple as that?
Mr. Chairman, I would answer my friend Senator Stewart by saying yes, it is.
Okay. I thought so. I think it's a really good bill and a really good idea, and there may be some minor snafus that we need to address along the way, but you know, I hate to admit this. Stanley's got a good idea.
Well, Mr. Chairman, I'm happy to finally make Senator Stewart happy about something in his life. It's taken 11 sessions to do that. But, you know, ultimately what we want to do is encourage that innovation and not have government get in the way so much, but actually collaborate and have our agencies collaborate together. And, you know, and there may be some really good stuff and there may be not so good stuff, as you say, and hopefully we'll be able to weed out the two. But the one thing that I do like is that not only with the collaboration, we are still involved as a General Assembly. And that we do not lose that authority in the regulatory process, but that we allow and unleash entrepreneurship and innovation in the Commonwealth of Virginia and take that step to where we're the leader in emerging industries.
All right. Is there anybody else has any questions before we get to public testimony?
Mr. Chairman?
Yes, Senator McPike.
Is there anything preventing a governor from directing his state agency head to do reviews of regs under their purview?
Mr. Chairman, I'd answer the gentleman by saying no.
Thank you.
I don't think so.
Yes, Senator Donovan.
But, Mr. Chairman, I'd also answer having somebody do a review of a reg and making a recommendation and actually acting in that is quite another thing entirely.
I hear there's tip lines out there now.
Mr. Chairman.
Senator Donovan.
Thank you, Mr. Chairman. Is it time to comment on the bill or no? Is it only for questions?
Well, you can comment now or after public testimony.
Well, I would just say that the particular nuance of this bill is the interagency interaction, which we have been challenged with forever. And we have sought to interconnect some of those agencies so that we can have more rapid movement with data in Virginia. This is another way for us to enable more rapid interaction and advancement by overcoming the silos that exist. And it's one that's directed by the legislature and appropriated by the legislature, which a governor cannot do. And so I want to point that out because this is not something that could easily be done by a governor.
All right. We will take public testimony now. Those in favor come forward.
Members of the committee, Mr. Chairman, Benjamin Knotts, Americans for Prosperity. I just want to highlight a few things. Senator Hoshmi had a question about the agencies. We actually were started out with a healthcare sandbox, and some of the bureaucrats were speaking to this, and they said, we don't have any authority. Senator Stanley had an idea a few years ago that had EMS using telehealth on site to treat people so that you didn't have to send them to the ER necessarily. So we tried to do this, and you had to deal with DMAS, you had to deal with EMS, and you had to deal with the Department of Health Professions, and they were siloed. And whose authority were they going to interview? And there was a lot of conflict there. And so in working with the healthcare sandbox, they suggested, well, who's going to be in charge to go talk to these other agencies? Because they're not going to listen to us. And so it became clear that you needed an independent agency to go between to set these kind of programs up, because there's multiple issues with establishing what Senator Stanley was trying to do with EMS. And just to give you a ballpark real quick about some of the opportunities that are out there, during the pandemic and during the summer of unrest, there was a lot of black-owned businesses that couldn't get access to capital because they were in red line districts. They actually used a fintech sandbox to do crowdfunding, to offer financial products at a very, very low interest rate so people could survive during the pandemic. And the banks couldn't do it because of the rules and regulations that limited that. Well, WVU actually has a sandbox for high school or for college students to attract them to an agency, so they can market their appearance and their brand. So it puts us at a disadvantage for recruiting a lot of these college students into Virginia, because you can't do that kind of thing otherwise. And I'm happy to answer any questions, and I'll sit down.
All right. Anybody else to testify in favor?
If you are in the Zoom room and would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
All right. We will go to anybody in opposition to the bill.
If you are in the Zoom room and would like to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, we have one speaker, Narsa Turner.
All right.
Ms. Turner, please unmute and begin your testimony.
Mr. Chair, members of the committee, can you hear me?
Yes.
Awesome, thank you. I'm Narissa Turner on behalf of the Virginia Conservation Network, and we are opposed to this bill. And it's my understanding that I think the majority of our concern just deals with how broad this seems to be. If it is just an attempt to sort of allow more innovation in certain sectors or aspects, that's totally fine. I guess we're just a little concerned that it could be used as a way to allow certain polluting industries to circumvent certain laws and regulations. And so for those reasons, we are in opposition. Thank you.
And what entity do you represent? Oh.
Mr. Chairman, if I may address that directly, I don't think in innovation, anything we're doing in this century says, let's make more pollution. I would think and would hope, and especially, again, this is why you have the collaborative effort and also the agencies working together, and especially when those agencies, our environmental agencies or whatever agencies, it is to find efficiencies and reduce those kind of pollutants and those things. So I dare say I wouldn't see this ever being something where someone comes in with an innovation, but it taints our water, that any governmental agency would say, oh, that's a great idea. So.
All right. We have the bill before us now.
Move to report.
Second.
All right, we have a.
Sure has got to go to finance.
And this would have to go to finance. All right. All right, we have a motion and a second to report and re-refer to finance. We can, if there's no further discussion, we can vote on the board now.
Senator Bell, how do you vote?
No.
Yeah.
Who's got Reeves's proxy?
8 ayes, 0 nays.
What?
Sorry, 6 nays.
Yeah, 0. I like 0 better.
All right. All right, this is reported and re-referred to finance.
Thank you, Mr. Chairman. Thank you, members of the committee. I appreciate it.
All right, next we have Senator Deeds. So.
Thank you, Mr. Chair. I've got Senate Bill 297. It's a very simple bill. It's what it says is if you are a victim of crime and you can get compensation from the Victims of Crime Compensation Fund, a health care provider can't take action against you until you've received compensation, or you know whether you're getting it or not. And if they do seek compensation against you, it's a violation of the Consumer Protection Act.
All right. Does anyone have any questions for the patron? All right. Yes, Senator Donovan.
I'm sorry. Could you clarify a little bit for me?
Sure.
The healthcare providers provided the care.
Provided the care a victim of crime. The victim of crime is entitled to compensation from the Victims of Crime Compensation Fund. So, and right now, they're not supposed to seek compensation until they know that fund's out there, but we're just making it a violation of the Consumer Protection Act here. There are instances where one specific instance I know of where providers have gone after people and tried to reduce things to judgment before while claims were still pending, I think, and then the claim was made was good, and it ended and resulted in litigation.
Mr. Chairman, follow up.
Senator Donovan.
Mr. Chairman, I understand the intent, but my question is, say your cars were stolen and you had to pay to replace your tires. Your tires were stolen. You had to pay to replace your tires. Would the person who owned the tire sales place not have to get paid until you got reimbursed for your crime? Or you got reimbursed for the criminal action?
I think that's another bill, Senator.
Mr. Chairman, Mr. Chairman?
Yes, Senator Donovan.
I don't understand why healthcare providers would need to wait in the provision of a service for remuneration that may or may not come to a victim, because it's not about the crime, it's about the health care.
Well, I think there may be a lawyer and a client in the Zoom room who can explain the circumstances of the case that brought this bill before you.
Mr. Chairman.
Yes, Senator Stewart.
One quick question. I understand what you're doing, Senator Dees, but what if the statute of limitations runs before they get the money from the fund? So then the medical provider's out. I mean, they can't ever get paid.
I don't think as a practical matter, I don't think that's going to happen, because I think that the Victims' Compensation Fund has to act within a certain amount of time.
But it could. I mean, they could not get their money.
I just don't see that happening practically.
But there's nothing to preclude that under your bill. And so if they don't get the money from the victim fund, and the hospital or the doctor has to wait beyond the statute of limitations, they can never collect.
Well,
that would be unfair, wouldn't it?
It would be unfair, but I don't think that's practical.
Senator
Donovan.
So just to follow up, just to give another practical equivalent, in cases where insurance plans have out-of-network providers and a healthcare provider, the contract between the healthcare provider is between the provider and the patient.
Right.
And we're interfering in that contract here. But I will say that in a case where a patient seeks care from an out-of-network provider and the patient is reimbursed by the insurance plan for that provision of care, who then in turn is to pass it on to the provider, I cannot tell you how low reimbursement for those health care provisions are, because the money never makes it back to the provider. It goes to the pocket of the insured. And so anything that obstructs the ability for health care to be able to maintain that financial relationship that's contractual is undermining, as Senator Stewart said, the opportunity for health care to actually implement the services and be reimbursed for them. And I don't understand why we treat it so differently than any other contract.
Well,
Senator Deeds and Senator Donovan, I think if you look at lines 16 through 20 of the bill, which is all existing language, it says that where the healthcare providers have been given notice of a pending claim, and they should refrain from debt collection activities. That's already covered in the law. And then you look on lines 19 and 20, and it says the statute of limitations for collection of such debt shall be told for the period in which the provider is required to refrain from debt collection activities. So
I think that addresses the question, the points of both Senator Donovan and Senator Stewart.
Right.
All this bill does is make it a violation of the Consumer Protection Act.
Mr. Chairman?
Yes, Senator Donovan.
And what is the consequence of violating the Consumer Protection
It
Act?
sets up a cause of action. What it says is if a healthcare provider violates what's already the law, they're going to get there's a cause of action against them. If they violate the law, if they don't read, if there's a healthcare provider out there, and I know that there aren't people like this, but if there is one that doesn't know the law and they illegally try to collect their money, and I will admit that they are entitled to be paid, but if they illegally, in violation of this code section, violate the law by trying to collect that money, they are also violating the Virginia Consumer Protection Act, and there are consequences for violating that act.
Yes, Senator Stewart.
Can't find it in here, Creed, but my recollection under the Consumer Protection Act is it's treble damages and attorney's fees.
And I would suggest that, and I'm not sure if that's so, there are probably people in the Zoom that can answer that, but I would suggest that might be an incentive for healthcare providers to know that what we've said, that they can't do this collection while this claim's pending, that the law means what it says. That's a real
question.
incentive.
Yes, Senator Stewart.
Don't medical providers have to give medical treatment? I mean, can they refuse people? I thought that they could not refuse people. So, I mean, they've got to provide this care, at least in some circumstances, and now you're telling them they can't get paid.
I think we've already told them they can't get paid. What we're saying with this bill is if you try to get paid anyway, you're violating the Consumer Protection Act, and there are going to be consequences.
Mr. Chairman.
Yes, Senator Donovan.
If nobody's doing this, why do we need to have the
Because people
Consumer
are doing
Protection
it.
Act?
People are doing it.
And
And I've got people in the Zoom room that can.
And there's no recourse for them now?
The recourse is to file a suit in federal court. There was on August 12th, 2017 in Charlottesville, there was a young man that was hurt when the car came through the crowd. Plowed his car into Mr. Baker, and Mr. Baker's on the line, and others. They asserted their recovery. Then somebody tried to attempt to collect a medical debt asserted to be owed to Mr. Baker to Charlottesville Radiology Ltd. for medical services provided to Mr. Baker arising from injuries that he sustained when struck by the car driven by James Alec Field Jr., for which Fields was convicted of multiple crimes and has been sentenced twice to life in prison because of the attack. They continued to put him on notice that they were going to do what it took to collect the debt while he had a claim pending under the Virginia Claims Act, Virginia Victims Fund, and and so he had to file a federal suit.
All right.
And so
we need to move along
Sure.
here, so we'll go to public testimony now, and that may help answer some of the questions and the comments that have been made here, and then we can come back to discussion and any further questions of the patron. All right, those who want to speak in favor of the bill, come forward.
If you are in the Zoom room and wish to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we have a couple of speakers, beginning with Jay Spear.
All right. Have Jay Spear testify.
Mr. Spear, please unmute and begin your testimony.
Yes, this is Jay Spear with Virginia Poverty Law Center, and we are in support of the bill. Senator Deed's bill does not create any new rights. It only gives a remedy to go along with the right that's already been there for several years. So it's really no change in the law other than to give somebody a way to enforce the law if the 99% of creditors do not violate this. There's just a smaller percentage that violate this, and there needs to be a remedy for people when it is violated. And the means of enforcing the law is the Virginia Consumer Protection Act, which is north of 40 statutes in Virginia law are enforced through the Consumer Protection Act. So I would urge you to vote yes on this.
Mr. Baker, please unmute and begin your testimony.
Hi, my name is Thomas Baker. Thank you for the opportunity to speak and share my experience with regard to this bill. So I was at the protests as a counter-protester at the Unite the Right rally on August 12th of 2017. And I was hit by the car attack by James Fields. I sustained very severe injuries, had surgeries, over a year of physical therapy, etc. And I couldn't incur major medical expenses with regard to this. So my medical expenses were eligible under the Virginia Victims Fund, and I had an active application with them and was working with them to receive those funds. One medical provider repeatedly contacted me to pay these bills, which were then responsible by the Virginia Victims Fund. They were contacted by my lawyer. They were contacted by Virginia Victims Fund. They were provided the law. They did not stop. So they sent my account to the National Recovery Agency, who then continued to harass me and attacked my credit score. This was also during a time when I was trying to purchase my very first home. This was flagged. I had a perfect good credit score. This ended up being flagged and severely complicated and even threatened the purchase of my home, all through an illegitimate debt collection activity. So your support of passing this bill would be massively beneficial to prevent anything similar from happening to any individuals in the future. Thank you.
Mr. Chair, I might suggest that in response to Mr. Baker's testimony, if you put the word on line 25 before violation, you put knowing violation, that would probably solve the problem, because it sounds like the creditor that was harassing him had full knowledge of, or they had full notice from the victims of crime fund and from other people that there were violation of the law.
All right, well, anybody in opposition to the bill can come forward and testify now.
If you are in the Zoom room and wish to speak in opposition to the bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
Mr. All Chair. Right, Senator Evan.
Yes, for Senator Deeds. For Senator Deeds. If I'm reading this correctly, this applies only when you're due these funds as a victim of crime from that fund. So you know you have money coming. It's just
when you've got a claim pending.
When you've got a claim pending.
When you've been a victim or an alleged victim of crime and you've got a claim pending.
And when you have that claim pending, during that time, you're saying to the medical provider, hey, we're going to try and pay you, but you've got to hold off till this is exhausted so I can get you some money that you're due.
And the amendment I suggested would fit the situation Mr. Baker was talking about, because if he's got it correctly, whoever the alleged creditor was, Charlottesville Radiology, had notice of the claim.
Mr. Chair, I move the amendment.
Second amendment.
The amendment was adding the word knowingly on line 25 prior to violation. Were there any? Yeah.
Mr. Chairman.
Mr. Chair.
I'm sorry, Senator.
Thank you. I just have a concern about the punitive nature of the bill and what it sounds like to me. I know that I would believe most healthcare providers, or the ones I know and interact with at least, really try to work with patients when they have trouble and they're struggling to pay their bills. So, and just not knowing how long the Virginia Victims Fund usually takes. I mean, it seems like it's not only is it punitive for healthcare providers, but also kind of leaves them out in the cold with no recourse for, and we have bills to pay, too. So I just have some concerns about the bill overall.
All right. Is there any other comment or question?
I have, just for clarification, Mr. Chairman, is this money from the Victims Fund paid to the victim or paid to the healthcare provider that sends the bill?
That I don't know.
Okay. And did I understand the speaker correctly, that they said they were approved by the Victims Fund?
My understanding is they were approved in the long run, yes.
So, but they weren't, I understood them to be approved at the time, which means that collection would have been appropriate.
No, it was pending, I think, before they hadn't received money. They were approved eventually. That's what the federal suit says, that they weren't alleged.
Mr. Chairman,
Senator Donovan, if you look on line 16, it says they have been given notice of a pending claim.
Yes,
so
no,
it doesn't have to be something that has been determined.
I understood that. I just must have misunderstood the speaker.
Okay. All right, Senator Stewart.
I just have to comment on this. I think this is crazy. It is punitive. And it's difficult. I don't even know why anybody wants to be a doctor anymore. I mean, the way that their fees are cut when you go to see them and they don't get reimbursed, and now you're going to tell them that they have to provide service to people, but yet they can't pursue the money that they are owed, and if they try to, you're going to hit them with treble damages, and they're going to have to pay the other person's attorney's fees. I mean, we're going to put doctors out of business.
Senator Stewart, if you want to tell them they can collect the money now while the claim's pending, change the law. That's already the law.
You're going to put doctors out of business.
I
and
got
it's
you.
very concerning to me because, you know, one of us might need one day, and I hope at least a few people will vote against this.
All right, is there, unless there's any other questions or comments, we'll take on the issue of what we do with this bill. So is there a motion anyone wants to make?
Move to report.
All right. We have a motion and a second to report. We have a substitute motion. Okay. All right. The motion is to report. And if there's no further discussion, we'll vote on the board.
Senator Bell, how do you vote?
Aye.
Nine ayes, 6 nays.
Thank you.
All right.
Mr. Chair?
Yes.
Before we move on to the next bill, I would ask that we reconsider a bill that I was absent for that was voted having voted on the prevailing side of SB 712. I'd ask that we reconsider that vote.
All right. We have a motion to reconsider the vote on action on Senate Bill 712. All right. We can deal with that after we do the reconsideration. So, all right. The motion is to reconsider the vote of 712. So we can vote on the board now.
Senator Bell, how do you vote?
Aye.
Huh? Yes, text Anthony.
14 ayes, 0 nays.
All right. We'll see if we can get.
Change my vote on the last one to a no.
Yeah.
Oh, we have to revote it? Not, because it doesn't change the outcome.
Yeah.
The one we just did on the Cree bill. I need to be a no. Sorry.
No, this is 712. This is a different. Yeah, okay, Senator, we'll see if we can get hold of the Senator Stanton and have him come back since there was a reconsideration that was voted for. And is that all he needs to do? Yeah. So, okay. No, we're not going to deal with the standing bill until we see whether we can get him back here. But I need to give him that courtesy there. So, all right, we have other bills from members of the committee. What's that? Huh? What'd you say? Sure. All right, Senator Evan. Sure.
Thank you, Mr. Chairman. I have SB 419, which is kind of a complicated bill dealing with your data privacy for direct-to-consumer genetic tests like 23andMe or Ancestry.com. And it's a lot of new language. So with the committee's indulgence, what I'd like to request is that it be carried over for the year with a work group in the interim so that members of the committee can look at it and we can hear from some witnesses in the interim.
All right. So we carried over the bill 419. Is there a second? Okay. All right. Is there any discussion on that? We will vote on the board.
Senator Bell, how do you vote?
Aye.
15 ayes, 0 nays.
All right. Are there other members of the committee who have a
Yes,
bill
Mr.
on
Chair.
the docket for today?
Couple down this way.
All right. All right, we'll start down at the far end. Senator Hashmi.
Thank you, Mr. Chair. If I could just remain here as well.
Certainly.
We looked at SB 200 last week, and this is the bill that would protect tenants who are reporting on failing septic systems to protect their identity from possible repercussion from landlords. We had the question about the FOIA issue, and working with council, we had the recommendation that we simply amend the language. So I believe there should be an amendment available.
It should be posted momentarily, Senator.
Thank you. I move the amendment.
Second.
All right, there's a motion and a second to adopt an amendment. All in favor say aye.
Aye.
All opposed, no. All right, that amendment is adopted.
So, Mr. Chair, the amendment simply strikes language. So if you're looking at starting line 111, where we added the language to protect the names and identities of the tenants who would be reporting or posting about on-site sewage complaints, the new language would simply read that records of active investigations, and that's the key word, active investigations and names, addresses, telephone numbers of the complainants furnished in confidence with respect to an active investigation of on-site sewage complaints made to Department of Health or the Department of Environmental Quality. That's what would remain in confidence, and we would strike the remainder of the language of line 113 through 116.
All right. Are there any questions on presentation by Senator Hashmi? All right. Are there people who wish to come, who wish to speak in favor of the bill?
If you're in the Zoom room and you wish to speak in favor of this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers in favor.
All right. Anyone in opposition to the bill?
Thank you, Mr. Chairman, members of the committee. Megan Ryan with the Virginia Coalition for Open Government. I do appreciate the senator addressing one of our main concerns, which was protecting the name of both of bad actors in this. We do still continue to have a problem with the phrase on-site sewage complaint, because without any kind of definition of that, that could be both a residential spill or an industrial or commercial spill. And so if the intent is to protect tenants from being retaliated against by their landlords, then this goes far beyond that. So thank you.
All right.
If you are in the Zoom room and wish to speak in opposition to this bill, please raise your hand electronically now. Mr. Chairman, there are no speakers.
Nobody else? Okay. All right. Then the bill is before us. We have adopted the amendment.
Move to report.
What was it?
Did we already do the amendment?
Motion to report. Yeah, you made a motion to
Move to
report in a
report.
second. Okay. There's a motion to report in a second. If there's no further discussion, we'll vote on the board.
Senator Bell, how do you vote?
Aye.
Fourteen ayes, 1 nay.
All right. That bill is reported. Senator, where did Senator Morrissey go?
He's in the hallway speaking on the phone.
We have a couple bills.
Yeah, if you can get him.
Keep moving down the road. Come on, keep moving down that.
All right. Yes. All right.
Against us up here.
Who down
so
there?
awesome.
Senator,
We're so nice.
Senator McBike. So.
Thank you, Mr. Chair. I have Senate Bill 217.
All right, 217.
And I might be out of practice, but I really wanted to provide a principled approach to tackling this bill. And as you can see, the entire bill is on line 15, which swaps the word practices with principles, Mr. Chairman. And the reason you can see on line 7, after the patron, This is by request of a constituent that ran across an issue with dealing with a HOA ombudsman, and the fact that the current code lists practices aren't actually the GAP principle. And so principles is actually the term of art that's used for accounting practices. So that is essentially the bill. There's been some opposition and concern from, believe it or not, the one-word swap from HOAs.
Yeah.
And I would like some resolution for this constituent. So I would ask that this committee continue the bill, but with letter to the chairman to do some follow-up with either the ombudsman or some of the HOAs to take a look at this issue.
All right.
And so move.
So this would be to carry this over and deal with it during the year. Okay, there's a motion and a second to carry it over. We'll vote on the board.
Senator Bell, how do you vote?
Aye.
Senator Mason's vote is not. Okay.
15 ayes, 0 nays.
All right, next is Senator Morrissey, and then we'll come back to Senator Stanley.
Are you kidding?
Yeah.
Good afternoon again, Mr. Chair, members of the committee. I'm here on Senate Bill 129, which is the use of alkaline hydrolysis for cremation. What this does is, it would be helpful, I think, if I can just define aquamation. It's a term that most of you probably have not heard of, one that I haven't heard of before this bill came to my attention. The process of alkaline hydrolysis is commonly known as aquamation, is a form of body disposal with similar results to cremation. Most folks know of regular burial. They have cremation. This is aquamation. Process uses 95% water, 5% alkaline metals, and it's currently used in 20 states. It's under consideration in several more, and it produces a finer and greater volume of ashes than traditional cremation. The environmental impact is somewhat overwhelming in that it has a less onerous effect on the environment. For example, traditional cremation can use the equivalent of 2 SUV tanks worth of gas, can result in mercury pollution, and other pollutants. Traditional burial, of course, can result in embalming fluids leaking into the ground after burial. The purpose of this bill is to allow, is to create a study group. That's it. That's all it does. And there's a couple of folks that are going to testify, but I'm somewhat unsure of any group of people that oppose a simply effort to convene a study group to study this process. There are a few people that are available to testify, Mr. Chair. There are some folks, at least one person online. But again, and I probably should have done this initially. Mr. Chair, I want to move the substitute. So I'm sorry.
All right, there's a motion and a second to adopt the substitute. All in favor say aye.
Aye.
All opposed, no. All right.
So if you look at that substitute, it's one page to simply that the Board of Funeral Directors and Embalmers, known as the board, convene a work group consisting of the relevant stakeholders. And all they'll do is they'll discuss at this work group the regulatory and statutory scheme, talk about necessary qualifications to enable somebody to practice aquamation, proper standards that will be used, proper requirements, regulation and implementation of the actual process. That's all this bill does. Before we go to any of the other people, perhaps, Mr. Chair, members, you have a question, I'll try to address it.
Mr. Chairman.
All right, Senator Reed.
I've been told that aquamation is a person who rides at the end of your ski rope when you pull them down the James River. Would that be true?
I've got 4 little ones that I engage in aquamation. Then, no, it's And up until about a month ago, Senator Reeves, I did not know what the term meant either, and I didn't know there was this process, but it's a third form of burial disposal.
All right. If there's no further comments now, we'll take public testimony. I don't have it, no. Can staff?
Mr. Chair.
Can staff let us know? Meg, can staff let us know what's in the substitute?
Let me talk to our IT person. Thank you.
Yes. Cyber.
The introduced bill has amendment has amendments from line 17 through 23, but there's nothing referencing the stakeholder group.
Mr. Chair, Mrs. Cyber is on in the virtual world. If you could call her to testify, please.
Do you have a substitute? Okay. All right, and what does it say about the study? Since that's the.
I'm sorry, Mr. Chair.
What does it say about the stakeholder group?
What does the?
Yeah. All right, Senator Evans.
Chairman, the stakeholders work together to amend the bill, but there's certainly, and they're available to speak for themselves. There's some people that oppose the bill. I don't know why. Apparently, as best I can glean, they don't like the definitions used in lines 20 through 23. But while you're locating Ms. Cyber, I'll call Mr. Dillard first and Mr. Bailey second to speak briefly.
All right. Senator Evans, do you want to say anything in particular or that? Okay. All right. We will have public testimony now. Those in favor, come forward and testify now.
If you're in the Zoom room and would like to speak in favor of the bill, please raise your hand electronically now. Mr. Chairman, we have Samantha Cyber here to speak. Ms. Cyber, please unmute and begin your testimony.
Thank you. All right. Chairman and members of the committee, thank you. I'm a biologist by degree. Over the past 16 years, I've helped over 40 states address this option in law and regulations. It made worldwide news last month when Archbishop Desmond Tutu selected this option. As was mentioned, the end result is very similar to cremation. The family receives an urn with ashes, but the process doesn't use fire, uses a solution of 95% water, 5% alkali. The flow of the water is very similar to a creek or stream, and so it's gentle to the final mineral remains, and that's why families receive about 30% more ashes than with flame cremation. No emissions, no burning of fossil fuels, 90% less energy. It uses less water than a household of 4 uses in a single day. No, there's no environmental contamination or any risk to any waterways. This is all validated in published studies. But this isn't an eco movement. Flame cremation is sacred for some cultures, as is burial. These choices are very personal. One family shared their story with me and explained that their dad spent every weekend at the lake, and this just seemed like a better fit when they heard it was an option. We've had a family of a fireman transport their father's body 8 hours to North Carolina because they wanted cremation but couldn't bear the thought of fire. There's been at least 12 Virginians who have had to transport their loved ones out of the state of Virginia to Maine and North Carolina, and I don't know how to explain how much hardship that adds to a family. And even worse, most local funeral homes don't even know that that's a possibility for a family.
All right, thank you very much.
Thank you.
All right. Are there those in opposition to the bill?
Yes, he does.
Mr. Chairman, I think you had one live speaker in
Okay.
support before I
In
oppose.
support, okay.
Mr. Chairman and members of the committee, my name is Randy Dillard, and I represent the Virginia Aquamation Cremation Society. And we are asked to bring this bill forward because there needs to be an alternative. We have tried to work with the opposition, trying to get some language that they all could approve on, because it's nothing better than having a unified front related to what this is. We don't want to change anything about how things are done in that industry. All we want to do is have this technology added. It's environmentally safe, and even from a standpoint of a person like myself who has knee replacements, if I had this process done, they could recycle my knees. And in addition to that, if I had a pacemaker, you can't cremate a pacemaker, you have to remove it. However, you can do that. So you can recycle some of those types of parts if you choose to do so. So I ask you to support this bill. Thank you.
Thank you. Yes.
I'm sorry, I didn't see.
No. I don't think anybody had any questions. Thank you.
Yes, Mr. Chairman, David Bailey, representing the same group as Randy. I'll be very brief. I think that we certainly made an attempt to work with those that you'll be hearing from next. If you look at the difference between this one page and the other introduced bill, this one really seeks to involve stakeholders, which was one of their requests, and we think this is a reasonable approach. It's the process doesn't need to be studied. How it's implemented, how it's licensed, how it's regulated, I think everyone agrees it should be studied. And Mr. Chairman, members of the committee, that's what's in the substitute bill.
All right, thank you. Senator, there's a question, Mr. Bailey.
Mr. Bailey,
David.
just wanted to ask, on lines 25 and 26, it says the Board of Funeral Directors and Embalmers shall promulgate regulations to implement the provisions of this act to be effective on July 1st, 2023. So if we're studying, if they're going to recommend how we would do this if the General Assembly made the policy decision, why do they need to promulgate the regulations now? Is this a study, or is it an enactment to go ahead and come up with regulations that would then become law?
Mr. Chairman, Senator Eben, in meeting with some of the stakeholders yesterday, some of the ones who today oppose this, they all agreed that the Board of Funeral Directors could convene 3 meetings, could convene the stakeholders, could get moving, and could then get moving on some regulations. The regulations certainly will not occur overnight. It will take a process. Back in the day, I spent 7 years on the Board of Funeral Directors as a citizen member, and we dealt with pre-need and all kinds of major issues. And if the board and the stakeholders meet, they can meet this timetable if it's your decision.
Mr. Chairman.
All right, thank you.
Mr. Chair, just to follow,
okay, go ahead.
Just to follow up, I thought that Senator Morrissey said that this was being changed to a study. So is it a study of how to do it, or if this bill passes, is it your intention that we would just go ahead and have this new way of human remains being disposed of would come without further policy decisions by the General Assembly?
Mr. Chairman, Senator Eben, it's my understanding of it that it is a study of how to regulate it, not whether to do it or not. I've heard from some of the ones even who oppose it that they don't oppose the process. They don't oppose that this being an option for families. It's the matter of the study of how it's to be regulated.
So just to be crystal clear, Mr. Chairman, if this bill were to pass, you're saying that this new way of disposing of remains would move forward without further revisiting by the General Assembly, or would it come back to us after it was studied for us to decide once and for all if we want to do this?
Mr. Chairman, Senator Abbott, members of the committee, looking at lines 16, 17, and 18, you see there is a report coming back. Now, I was one of the opinion that it was your committee that oversees this. I think it was the folks who opposed the process moving forward, who wanted to suggest that it be a report back to Education and Health and HWI. Personally, I think it's wherever you want the report to come. I thought it should come to your committee and to the House Committee on General Laws.
Last comment, Mr. Chairman.
Sure, Senator Evans.
The problem I have with the bill is promulgating regulations if it's in fact supposed to be a report on how to do it. I don't know that we need to go ahead with the regulations unless we're all agreed that this new way of disposal of remains is something that we want to move forward today. And I don't know that there's consensus on that or if that's Senator Morrissey's ultimate goal with this bill.
No, thank you for that question, Senator. I do not object to, and I understand your point, striking lines 25 and 26, because I do see the inconsistency between what's put on 25 and 26 and the language set forth in 13 at sequential. So maybe, if, Mr. Chair, if there wants to be a motion to strike lines 25 and 26, I would consider it friendly because, as I said at the beginning, this is to convene a work group.
All right, thank you.
I would make that motion.
All right, Senator Evans made a motion to strike lines 25 and 26 of the substitute. Is there a second? All right, all in favor say aye.
Aye.
All opposed, no. All right, that is adopted. Senator Donovan, did you have anything? Yes, sir. Okay. All right, now we'll go to those who are opposed.
If you are in the Zoom room and would like to speak in opposition, please raise your hand electronically now.
Yes, proceed.
Mr. Chairman, Scott Johnson on behalf of Services Corporation International. We are not opposed to alkaline hydrosis. Virginia does not have any statutes on how to do it. Our Board of Funeral Directors does not have any regulations yet. Senator Evan is exactly right that we need a study by the Funeral Director Board, have them report back to you so you can know what statute to pass, and then they can promulgate the regulations. But let me break a little code that's going on in this bill. Look at lines 19 through 23 or 24 in the substitute there. You see the word aquamation. That is a proprietary term that we understand applies to one company in Illinois. So if you're striking things in the substitute, if you went ahead, in addition to striking lines 25 and 26, which we thank Senator Morrissey for taking out, take out lines 19 through 24 on those definitions, and my opposition goes away, and I think my counterparts behind me that are opposed to the bill, their opposition would go away. Why define a term for a proprietary company and tie the hands of the Funeral Director Board? Thank you.
All right, we have a motion and a second to eliminate the definition lines that use the word aquamation and aquamator.
19 to 24.
19 to 24, okay. All right, there's a motion and a second. If there's no further discussion, we'll vote.
Mr. Chairman,
Yes.
before we vote on that, I'm listening to Senator Stewart out of my left ear, and there's aquamation is in the breast of it, line 12 as well. Because there is a practical, I'm just being practical, I type in aquamation, it takes me to alkaline hydrolysis, which is also known as biocremation, resomation, flameless cremation, aquamation, or water cremation. So I don't doubt that there's a company somewhere that's named that, but I'm just, do we need to take it out of line 12, Mr. Chairman?
Mr. Chair, why don't we just use the words alkaline hydrolysis? How about we do that?
All right, so we will use alkaline hydrolysis, and we don't have to say known as aquamation.
Mr. Chair, and to the committee, there are a couple other instances where it's using aquatorium and aquamator. With y'all's permission, we can clean up throughout in the sub, all those instances.
All right, so
that we just are using aqualine hydrolysis.
all right, is there a motion to drop the words aquamation, aquamator, aquatorium, et cetera, all the aquas, and to replace, if need be, with the alkaline hydrolysis?
Mr. Chair, I don't know if there's objection to an aquamator or aquatorium. I do understand the suggestion that aquamation was a proprietary term, so that's why I suggested we just remove that, but.
Mr. Chair, my concern
there
with
any
using
angst about
aquamator and
aquamator?
aquatorium is that there won't be defined in this bill after we take the definitions out, so they might sort of be strange words, and so if we just are a little bit more descriptive instead of using a term.
Sure, okay, I understand that.
All right, is there a motion to do that? All right, motion and a second. All in favor say aye.
Aye.
All opposed, no. Okay, those amendments are adopted there, so.
Mr. Chairman?
All right.
Did we also strike lines 19 through 24 in that motion? Just want to make sure we either capture it or we have not, so, okay. Council's nodding their head yes, so thank you.
All right. Yeah, that's fine. All right, we can go back now to the testimony of the opposition, so.
Mr. Chairman, members of the committee, Bo Keeney representing the Association of Independent Funeral Homes of Virginia. We thank Senator Morrissey. With those changes, we have no objection.
All right, thank you.
Mr. Chair, members of the committee, Jeff Caruso with the Virginia Catholic Conference. We have not seen the substitute, nor have we been involved in the stakeholder discussions. But what we did want to share is that from what we understand from other states, the way that the soft tissue is dissolved in the solution, the resulting liquid is about 100 gallons, and sometimes it can be disposed of in the sewer system. That's what we understand the process to be in other states. And in our view, disposing of remains in this way fails to fully respect the dignity that is owed to the deceased. We also do know that it can alter the chemical composition of large amounts of clean water, and so for these reasons, we would oppose the bill. Thank you.
All right, anyone else speaking in opposition?
Barbara Allison Bryan from the Department of Health Professions. With the revisions that we've just heard, the Department of Health Professions and the Board of Funeral Directors is happy to host this work group.
All right, thank you. All right, anyone else in opposition? No.
Move to report as amended.
All right, okay. All right, the bill is before us. All right, there's a motion to report as amended. Is there a second?
Second.
All right, we have a motion and a second to report as amended. We will vote on the board.
Senator Bell, how do you vote?
Aye.
14 ayes, 0 nays, 1 abstention.
Thank you, Mr. Chairman. Thank you, members.
Certainly. All right, Senator Stanley.
You call.
We were missing you, so.
Missed you too. Well, don't make me explain this again, Mr. Chairman. I understand that perhaps one senator wanted to reconsider.
All right.
I thought I closed well. Go ahead.
All right. Is there anything you wish to say, Senator Stanley?
Please?
Yeah. Is there any questions of the patron?
For real?
Just testing. So, all right. The bill is before us now. So.
Wait, no, yeah.
All right, we got
okay.
a motion and a second to report.
And re-refer to finance.
And re-refer to finance. Yeah.
As amended.
We'll vote on the board.
Senator Bell, how do you vote?
No.
I'll remember that.
8 ayes, 7 nays.
Yeah.
All right.
Thank you, ladies and gentlemen, for bringing me back.
All right.
Just to create some more torture. I'm always for that, Senator Markle.
All right.
Mr. Chairman.
Yes. All right.
You can win, Stanley. You can win.
You have Senator McFeith. You got a bill?
Yeah. Yes, Mr. Chair. I have Senate Bill 224.
All right.
So Senate Bill 224 is actually the work from a bill I put in about 2 years ago. It was a concept requiring more transparency at the local government lobbying level. And as a result of that, the bill was referred to the Ethics Council. And due to COVID, the Ethics Council took a little bit of time. And so this year they finally took up the concept.
All right.
And so they did recommend the bill that's before you. I do have a substitute and would like to offer the substitute that is online, and it would move the adoption of the substitute.
All right. There's a motion and a second to adopt the substitute. All in favor say aye.
Aye.
All opposed, no. All right, the substitute is adopted.
Thank you, Mr.
Explain
Chair.
what the substitute does.
So the substitute, it actually takes the sort of what was passed through the Ethics Council and helps to basically mimic what we already do at the state level. And so it provides basically the same exemptions, and it provides a method for anybody who's doing lobbying at the local level to simply go through our Secretary of the Commonwealth to register through the same portal that is done today with a $25 fee, if it's just one locality, or a blanket fee for any localities for $75 to help just cover some of the administrative fees. They don't have to fill out the same reporting standards that they do at the state. It is simply a notice that you have a individual that's being paid to lobby your local boards, regional commissions, et cetera, and provides that notice to the state. So it's really about the transparency of realizing that it does now have a new fiscal impact. It will likely have to be re-referred to finance with the substitute. Mr. Chairman, that is the bill.
All right. Mr. Chairman. Yes, Senator Ruff.
I would ask, I got some input from some of my chambers of commerce that they would be picked up on having to be registered as in this process. Does the substitute relieve them of that $25 fee?
So, Mr. Chairman, I'd answer the senator. If you look to the exemptions are line 12 through about 33. And so if there's a principal person who's paid, for instance, less than $500, they would be excluded. Dollars. If there's a person incidental that's providing testimony and public testimony as a part of their job, they would be excluded. And so that sort of mimics the existing framework that we have the state. And so you'll see lines 23 through 24, 25. So if they're providing formal testimony at a public hearing, they would not have to, this would not apply to them.
Mr. Chairman, if they just came to Richmond to talk about business issues overall, but not specifically to testify about a bill, would they be picked up in that?
So that'd be picked up under existing law, Mr. Chair, under our existing state lobbying code. So they would either qualify or not qualify based on the existing code. This applies that existing code to the local lobbying provisions.
Mr. Chairman?
Yes, Senator Reeves.
Maybe to Senator Ruff's point, I think on lines 32 and 33, maybe council can give us some legal advice. Would that resolve Senator Ruff's issue? I have the same with the Chesapeake Bay Foundation and some others.
Mr. Chair, Senators, the bill is actually just focused on someone who's going in lobbying or being compensated to influence or attempt to influence a local government action. So for an organization that would be coming to Richmond, regardless of what they were going to be doing here at the General Assembly, they would not be captured under 2.2.421.1. Whether they are required to register as a lobbyist under our current law, I don't have that answer off the top of my head, but as long as this bill is only dealing with local government actions, local government officials, and certain types of actions aren't actually going to require that written notice.
All right, yes.
I've got a question for somebody. So, for instance, in the Northern Neck, we recently had a petition to name the Rappahannock River a scenic river. And there's a group called Friends of the Rappahannock. And they're largely, it's a lot of volunteers, but there's a paid director. And he testifies, if you all recall. If I read this bill, because he is paid by the organization to run the organization, and then he would then come to the Board of Supervisors in one of the counties in the Northern Neck to lobby to call that river a scenic river, right. He's got to now register with the SEC or whatever as a lobbyist and pay a fee. Am I reading that wrong?
Mr. Chairman, this isn't actually going to require them to register as a lobbyist or to pay the registration fees. It is simply a written notice requirement. just to let them know, hey, I'm this person, I'm paid by these people. I'm going to be coming and talking to local government officials about this particular action. And then that's the $25 fee for that notification. But it's not going to then require them to do all of the jumping through the hoops as far as lobbyists, who I think everyone here probably knows about all the forms y'all have to fill out.
So the answer is yes?
No.
Not the same.
I'm sorry. They don't have to register, but they've got to pay a fee and give notice.
Yes, they would have to pay the $25 fee and give the written notice that they will be going and attempting to influence action on a certain local government issue. But they are not then subject to all of the other registration and reporting requirements for lobbyists.
Okay, thank you.
So, Mr. Chair,
Yes.
to speak to Senator Stewart's question, there are many things that have come up controversial across the Commonwealth in the last few years. And whether you're for or against something, what the bill seeks is transparency of who the actors are and what's going on behind the scenes. Right now, you have zero transparency, whether it's an environmental project and whether you're for or against something. I've seen in localities folks, all of a sudden community leaders take a different interest, or different folks appear in the community and start talking about different issues. And whether it's been from some of the controversial projects across the Commonwealth to so many other different things, the fact is we think we're important in Richmond. However, local governments approve billions of dollars worth of budgets and land use projects and other things that have significant impacts all across the Commonwealth. And so this is actually lighter than we do for the decisions we make, but it at least provides the modicum of transparency of who are trying to impact our local government decision making.
All right. If there's no further discussion or questions of the patron now, would anybody in support of the motion like to come forward and testify?
If you're in the Zoom room and would like to speak in favor of this bill, please raise your hand electronically now. There do not appear to be any at this time, Mr. Chair.
All right. Is there anyone who wishes to speak in opposition to the bill?
If you are in the Zoom room and would like to speak in opposition to this bill, please raise your hand electronically now. There do not appear to be any in the Zoom room at this time, Mr. Chair.
All right. Come forward and present your testimony.
Hi, Michelle Gowdy from the Virginia Municipal League. We thank Senator McPike for bringing this bill, but we have significant concerns, especially first about our small towns. Let me just talk about the small towns. We have small towns where there's one tractor dealership or there's one business that comes to lobby the local government, and they all of a sudden would have to pay $25 every time they came forward, which is significantly concerning to us. The second piece is, now that we have to go to the secretary, that's a whole different ballgame than going to the local clerk. And what is going to be the responsibility of the locality to know if that person's registered or not? So we have significant concerns about the change to the secretary versus the local clerk. Thank you for your time.
All right, thank you.
Mr. Chair?
Yes.
Can you return? This bill has been out there for 2 years, and so I'm just curious as what is a resolution to some of the issues, because the local governments in counties and VACO and VML continue to find excuses to oppose transparency, which is baffling to me.
So, Mr. Chairman, Senator McPike, with all due respect, I had spoken with your aide earlier this year, and last year we talked about setting a population threshold, and I put that out there a couple of years ago as one of the options, and so I think that there's some way to talk about that if that's a path forward.
Mr. Chairman, follow up. Would you not agree that actually utilizing the secretary is a lot easier than the prior complaint that you provided 2 years ago, which is you did not want the local clerks to file and handle the paperwork because that was too much of a burden? So now the substitute now alleviates 100% of that burden and puts it to the state as a state responsible way to provide transparency. Would you not agree that's easier?
So, Mr. Chairman, Senator McPike, I would not agree, because I don't know what the local government responsibility is at this point to understand what they have to know. I mean, it seems to me that the Secretary of the Commonwealth has to provide that information to the locality, which would be the clerk again.
All right.
Thank you. Yeah. Thank you, Mr. Chairman. I'll speak to it in a moment if we take more speakers. Thank you.
All right. speaking in opposition, so.
Thank you, Mr. Chair, members of the committee. Patrick Vanning with the Chesapeake Bay Foundation had a chance to speak to the patron. We don't oppose transparency. We appreciate the intention of the bill. We primarily have a technical concern. We appreciate working with the patron on the substitute. Our concern is that we have many employees, as some of you have mentioned, who are engaged at the local level on a number of projects throughout the Chesapeake Bay watershed. And so our concern is making sure that they would be registered in all of those localities, and in particular within the time constraints that are set forth in the bill. And I would draw your attention to lines 45 and 46. And the way that I interpret that language is that we would have an obligation within 15 days from initiating any of these local activities that are covered to register in each of the localities. And we're happy to register. Having to do so within 15 days to cover all of my colleagues would be a challenge, and we would be facing a criminal penalty for violation if we could get clarity on that aspect of the bill, and if we could sign up at the beginning of the year for all the localities in which we might be operating, we'd be happy to do so.
Mr. Chairman, if I could defer to council on that issue, just to clarify, and I believe it's on the 15-day issues on line 45, after to the Secretary within 15 days, I believe that is the question.
Mr. Chairman, I'm not sure I quite understand what the question
so
is.
I want to make sure we clarify your concern with that, line 45 and the 15 days.
Yes. Thank you, Mr. Chair, Senator McPike. So the way I read it is within 15 days after first communicating. So the clock wouldn't start ticking until you've initiated that first communication. And then we would only have 15 days. And again, I'm covering a number of my colleagues who participate in this kind of work at the local level. So that's our concern.
Mr. Chairman, I think I understand the confusion. Within 15 days after communicating or attempting to communicate, that's going to set the deadline. So it's 15 days after that happens. But there is nothing that would prevent a person from filing this notice and paying this fee in advance of that initial communication. If you knew you were going to hit up every locality in Northern Virginia, you could go ahead and start filing that notice and paying that fee. Just would have to be completed by the 15th day after your first communication.
Okay, we appreciate it. That addresses our concern. We're happy to sign up at the beginning of the year for all the Bay jurisdictions. Thank you.
Mr. Chairman.
Yes, Senator Mason.
So it looks like on line 38, an individual who is compensated to influence or attempt to influence a local government action through oral or written communication. I mean, that sounds like it attempted to be narrow, but it certainly wouldn't include the tractor supply guy. I mean, he has a business. I mean, just because he goes and speaks to local government doesn't mean he's compensated to do so. But I guess the Chesapeake Bay Foundation maybe. I mean, is there a way to address that line that alleviates some of the concern of a normal citizen who runs a business going down to City Hall and saying this local ordinance is a problem for me? Sorry, that's a useless question without a solution, but I read that to be pretty tight, but it seems like that's not tight at all.
Mr. Chair.
Yes, Senator.
I don't find Senator Mason's question useless because I think there's that degree of ambiguity around the word you get a pat on your shoulder there. There's that ambiguity around what is really lobbying. If it's a local businessman going to talk to a council member, is that lobbying? Or is it seeking to address a concern of the local business? So I think we do need to tighten the language around what we mean by lobbying in this regard.
Mr. Chairman, if I could.
Yes, Senator McPike.
The qualifying language of the exemptions under 420 and then 421, which are in this bill. You look at line 9, an employee of a business or other entity of local government whose job does not regularly include lobbying. And so Tractor Supply is a business guy going down to pay his taxes. That's not going to qualify. I mean, so if you read the whole context of the intent and then look through the exclusions, you build a full picture of what this bill does. And it helps to avoid what Senator Mason identified as well as the earlier speaker on exactly that. So it, in fact, as written, does keep out the day-to-day person going down to ask about their taxes or asking about an adjustment or anything that in due course of business. So if you read through, it does provide the exact exemptions that our currently lobbying corps here in Richmond does, and also applies that here to local government as well.
Where's that in the substitute?
All right. Are there other questions of the patron? All right, the bill's before us for consideration.
Mr. Chair,
Yes, Senator Vogel.
given some of the sidebar conversations that we have had here and some of the questions that have been raised, I'm going to make the motion that we gently PBI the bill.
All right. All right, there's a motion and a second.
With all due respect to the patron.
Passed by indefinitely. If there are no, is there any further discussion? No, if there is none, then we'll vote on the board, so.
Senator Bell, how do you vote?
No.
Seven ayes, 7 nays, 1 abstention.
All right, the motion fails. Yeah.
Move to report and refer to finance, just so I can add my punishment to another committee, since this has added a fiscal impact, which may help reserve some other discussions.
This bill was not requested by finance. So.
I'm sending it there anyway, which you'll hear a patron never say ever in their life again.
Yes.
I'm sorry, but I read slow. But I was going back and looking at what Senator McPike said on line 32, and it says an employee of a business, other entity, or local government whose job duties do not regularly include lobbying. What does that mean? Because if you are an employee of a business and the local government's making decisions regularly that affect your business, and they designate you to go down to the courthouse to the public hearing and do public comment or call them about issues, are they regularly lobbying? Because that's every business. That's every business in a locality, and they typically have an employee who goes and talks to them. So I'm really confused by that. I don't know what that exemption means. And I think it would mean if you're only going to go talk to your local board of supervisors one time, then you're not regularly lobbying. But there's no such thing when it comes to running a business in a small community. You're always talking to the board or county administrator or something, lobbying their efforts. And the same's true in a city, I think.
Yeah, Mr. Chair, I just note that that's existing context that we apply to Richmond. So I don't see a line of people that are getting Class 1 misdemeanors here in Richmond. The same provisions, same exemptions apply here as well.
All right.
Mr. Chair,
Yes,
I'm going to ask staff if she'd like to comment on this. Meg, would you like to say something?
Madam Chair, no, I do not.
Meg, that's not true. Okay.
Given the deadlock we have here, I would say that we should pass this bill by for the day. Anyone want to make a motion to that effect? All right. All right, we have a motion and a second to pass the bill by for the day. All in favor saying aye. All opposed, no. All right, that bill's passed by for the day.
Thank you, Mr. Chairman.
All right. Senator McClellan.
Yes, you should have.
Good afternoon, Mr. Chair. I have Senate Bill 477, which changes the date for historic African American cemeteries that are eligible for maintenance funding to 1948. And I do have a line amendment.
Thank you, Mr. Chairman. On line 30 of the introduced version, after the word who, strike lived at any time between January 1st, 1800 and January 1st, 1900, and insert were entered in such cemetery prior to January 1st, 1948.
So here's the reason for the bill. Right now, there are lots of African American cemeteries in need of maintenance funding that have people that were interred between January 1st, 1900 and 1948, because it was until 1948 that that many cemeteries were still segregated, either by law or due to racial covenants or deeds that the Supreme Court struck down in the Shelley versus Kramer case in 1948. And so that is the reason for the bill, to ensure that those cemeteries where people were interred while cemeteries were still segregated and African American cemeteries were not given the same care and maintenance as non-African American cemeteries.
All right. Is there action we need to take to address the issue here?
I think you need to adopt the line amendment and then report the bill.
All right.
Mr. Chair, I move we adopt.
I was going to say, I was waiting for somebody to say
Mr. Chair, I move we adopt the line amendment.
All right. All right. We now know that 1948 is the new 1900, so.
Yes.
But replace that. All right. All in favor, say aye.
Aye.
All opposed, no. All right.
Second.
All right. If there's no one in the audience who wishes to testify on this, we can proceed along. So we'll do the, I don't think this one. Oh, yeah, this one has to go to finance, yeah.
I move a report and re-refer to finance.
Right. All right, we have a motion to report and refer to finance. Second, and you have a second, and all in favor of that will vote on the board, so.
Senator Bell, how do you vote?
Aye.
He's gone.
15 ayes, 0 nays.
Thank you, Mr. Chair.
All right.
Man, oh, man.
Next, with bills down this end.
Mr. Chairman, I have a bill as well. That was actually testimonies heard on it last week.
All right, we'll let Senator Bell go, and then we'll come to Senator Locke, so.
You know who you are.
Mr. Chairman, this is SB 550 on subcontractor payments.
Oh, gosh.
Yeah.
Mm-hmm. I wonder where they
Are we ready? All right. We've worked a great deal with the stakeholders on this, and I want to first thank AGC and their stakeholders for working with us so much on this. We haven't come to any changes we have agreed on yet, but we have agreed that we think we're going to get there. The insolvency is the only thing right now we're kind of really hung up on. We believe we can work through that, and we've agreed to go ahead and press forward today. With the bill as is, with the agreement, we will continue to work together in this cooperative manner. As a reminder to the committee, this bill really is focused on subcontractors getting paid. We've had a issue with out-of-state companies coming to Virginia and not paying subcontractors. Not a problem with Virginia companies. And ironically, some of the bad actors in this are from states like North Carolina, where they have requirements already that have been in place for 30 years requiring them to make these payments. So for many of them, it's a new condition in Virginia, but it's not a new condition for their company. But having said that, I believe we've had some very good, deep discussions, multiple discussions, and we are where we are. At this point, I'm not offering an amendment, and ask that we, with the agreement, we will continue to work on the one area we think we can improve, that we move forward.
All right. Well, is there a substitute?
The substitute should be posted online.
And Mr. Chairman, I guess did we not adopt that last week? 'Cause I thought we adopted that last week.
Move the substitute be adopted.
Second.
All right. Motion and a second to adopt the substitute, in case we haven't adopted it already. All in favor, say aye.
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 All opposed, no. All right, that is adopted. We had heard public testimony last week on this, so we don't need to redo that. So now we're up for consideration of action. And this bill, if it were reported, we would.
Mr. Chairman, I think we
yeah.
Mr. Chairman, so we had some testimony last week, and I hope we don't relive it, but are both sides in agreement to what Senator Bell just said?
Mr. Chairman, Matt Bentke with the Virginia Contractor Procurement Alliance. I'm not sure what agreements or discussions have been going on between AGC and the other subcontracting group. We're empathetic to the problem, but the fact of the matter is this bill is requiring general contractors to pay without a process, and that makes no sense to our group. And I think there's a lot of other people that feel that way. We have met with the proponents of this bill, and I do not personally feel that there's going to be a way to resolve this issue. And I know there are other people that would like to speak as well.
Again, as we discussed last week, there's two parts to this bill. One is for the state public bodies. The other is where you're trying to tie in private parties. The stakeholders have already said that basically as far as the public bodies, they don't have an issue. They've already said that we don't have a problem. And on top of that, there's a 100% payment performance bond that protects public bodies and protects those contractors. My question that I asked last week and asked during our conversations with all the stakeholders is basically in paragraph 1, subdivision 1, you're taking out condition precedent. You're making it unenforceable. Okay?
We've heard this testimony already. If we're not going to give everybody a chance to testify, I don't think we should hear this again.
Try to wrap it up quickly, please.
Okay. You're basically saying it's unenforceable. Right. Is that saying that basically those two particular subdivisions, 22 through 26, they're not enforceable anymore after this code passes? The other part I have is on 54, line item 54, where you tie it back to under 11.4.6. Bring this provision over. You're trying to tie it to private bodies, but you don't carry forward line items 22 through 45, which are the subdivisions, which basically carry on what the payment clauses are supposed to be.
Right. All right. Thank you. And we'll move on to action on the bill now.
Mr. Chairman, if I could make a closing remark.
Certainly.
Yeah. Thank you. Frankly, it's disappointing to hear Mr. Binka and his folks basically come up there because the only option they offered was to kill the bill and wait. And for the subcontractors not getting paid, that's not acceptable. The AGC and their members worked with us. I believe the people who stepped up, that represents two companies. AGC represents many. And frankly, while I agree we need to work on the insolvency portion, Virginia subcontractors not getting paid is not right. And this is, again, something they've lived with for many years in North Carolina, I think 30 years. So with that, I ask that we pass the bill.
Move to report.
All right, we have a motion to report. Is there a second to the motion to report? Second. And re-refer to finance.
Mr. Chairman?
All right.
Can I make a substitute motion?
You may.
Mr. Chairman, I make a substitute motion to pass the bill by gently, and I have the greatest respect for the patron, and I agree with what he said in many respects, but it's very concerning to me when we start getting in between these private contracts. And we're not forcing people to enter into contracts, and these are business risks and business decisions that these entities have to make, and I think it's a mistake for us to jump in the middle of it, and perhaps if they're left to their own devices, they can work this out.
All right. Is there any other comments? All right.
You need a second for that substitute.
Yeah. What was it? Is there a second for the substitute? All right. The substitute motion is to gently pass by indefinitely. And if there's no further discussion, we'll go on the board on this, so.
Senator Bell, how do you vote?
Well, I appreciate the gentle. I still vote no.
4 ayes, 11 nays.
All right, then we go back to the main motion, which is the to report and to refer to finance. So we'll go on the board and vote now.
Senator Bell, how do you vote?
Aye.
10 ayes, 4 nays, 1 abstention.
All right, 10 ayes, 4 nays, 1 abstention, and this will be referred to finance. And will be heard next week, I guess, so. All right, Senator Locke.
I was taking a nap.
Is that it?
Yeah.
Okay, I have two bills. The first is Senate Bill 23, which, if you recall, Senator Norman's Senate Bill 76 was rolled into this one, and there is a substitute, so I move that we adopt the substitute.
All right. All in favor, say aye.
Aye.
All opposed, no. All right.
Okay, in 2017, the Commonwealth created a Historical African American Cemeteries and Graves Fund, which is administered by the Virginia Department of Historic Resources. This legislation changes are suggested in order to, requesting some changes in order to address existing challenges for localities in an effort to try to access the funding. Many of the cemeteries are privately owned or neglected, and it may not be feasible or desirable for the locality to obtain ownership. However, there are instances where it would be desirable for the locality to be able to supplement its efforts to address general maintenance issues such as mowing and specific maintenance issues such as collapsed graves by having access to the fund. So the purpose of this legislation is to amend the code to be modified to enable eligible localities to apply directly for the extraordinary maintenance grant funding rather than needing to first obtain the regular maintenance funding. So that's the purpose of this legislation.
All right. Are there any? Is there anyone in the audience who wishes to speak?
If you're in the Zoom room and would like to speak in favor of this bill, please raise your hand electronically now.
Just very quickly, thank you, Mr. Chair. Thank you, Senator Locke. Ed Reed, Two Capitals Consulting on behalf of the City of Hampton. We appreciate Senator Locke for putting this bill forward as a main priority for the City of Hampton in their legislative package this year. And I know there's at least one person from the city online that would like to also speak. Thank you.
All right, next.
Chair, members of committee, Emily Reynolds with Access Point Public Affairs representing the city of Suffolk. We have about 16 African American cemeteries that would benefit from this legislation. We ask that you support the bill. Thanks so much.
Thank you.
Sherry Neal, please unmute and begin your testimony now.
Yes, good evening.
Yeah.
Members of the committee, Mr. Chairman, Sherry Neal, Intergovernmental Affairs Manager for the City of Portsmouth. We thank Senator Locke for bringing this forward. The City of Portsmouth was the second city in the Commonwealth of Virginia to be able to take advantage of this. It's been very helpful to us for the local governments, and we do have some other cemeteries and plots that this would be helpful with. So we hope that you will support this. Thank you.
Angela King, please unmute and begin your testimony now.
Good evening, Mr. Chair, members of the committee. I'm Angela King with the City of Hampton. Thank you for the opportunity to provide remarks in support of SB 23. As Senator Locke stated, there are instances where it would be beneficial for localities to be able to access the funding, even if they do not own the cemetery. Therefore, the city supports the expansion of the definition of qualified organization to include localities which apply for the fund for the purpose of maintaining a neglected cemetery within its jurisdiction. Additionally, the city supports modification of the language in subsection F because it will enable localities to focus their efforts on the more involved public health and safety issues such as collapsed or exposed graves, while leaving the regular maintenance funding available for other qualified organizations to obtain. Again, thank you for the opportunity to provide these comments, and I'm available to answer any questions.
All All right, as that includes the public testimony. So the bill is before us for action.
As amended.
Right. All right, we have a motion to, a second to report as amended. If there's no further discussion, we'll vote on the board.
Senator Bell, how do you vote?
Aye.
15 ayes, 0 nays.
All right. Senator Locke, do you have any other?
The second bill is Senate Bill 24, which simply extends from July 1, 2023 to July 1, 2024, the expiration date of the eviction diversion pilot program. And this was a bill coming from the Virginia Housing Commission. And the reason for the extension is because the program could not go into effect because of COVID. So it was delayed a year. So this is simply to allow for an extension for a year.
All right. Any questions of the patron?
Move the report.
Second. All right. Is anyone who wishes to testify?
If you are in the Zoom room and would like to testify in favor of this bill, please raise your hand electronically now.
All right.
There does not appear to be any at this time, Mr. Chair.
Okay, thank you. All right. We have a motion that is made. Is there a second?
Second.
To report the bill. Okay. We will vote on the board. So.
Senator Bell, how do you vote?
Aye.
14 ayes, 1 nay.
All right. Any other bills?
Yes, I've got one.
Senator Locke. Senator Locke.
I've got one. Are you finished, Mimi? Yeah, she's finished. I've got one.
Senator Vogel.
Thank you, Mr. Chair. I have Senate Bill 324. This bill is pretty straightforward. It adds to the list of exemptions from FOIA information related to activity, support, participation in a 501c organization. The background is that Virginia is the 7th most charitable state in the country. And we have made, as a public policy matter, a decision that we want to incentivize people to give to make charitable contributions and to give to 501c organizations. And so at the federal level, the way we've done that is we have said that in order to incentivize that activity, we're not going to subject donors to harassment and we're going to protect their privacy. And the Supreme Court has upheld that. And so when you, for example, make a contribution to a charity or to a C4 organization, that organization will actually file a 990 tax return, but that Schedule B of donors and donor information is never, ever disclosed by the IRS. And they do that to protect donor information. What we have in our current FOIA statute is not anything that would protect that information in the Commonwealth of Virginia. So for those of us who are engaged in the ordinary practice of law, we're always very careful to redact that information. If you have to produce a 990 tax return for a client, you always carefully redact that. But we don't have that protection in our code. So states have been careful to do that. Some states have actually tried to go the other way, and the Supreme Court has struck that down. So what my bill does is simply do that, and you'll notice that it just adds that language in on line. This is a substitute, so I need to move the substitute in a second, Mr. Chair, but on line 93, it just says that names and the information. Substitute been moved.
Make a motion. The motion before us is to adopt the substitute. All in favor say aye.
Aye.
All opposed, no. The substitute's adopted.
So I think, Mr. Chair, I perhaps have talked it to death, but it's a great bill. So there you go. And there may be some Zoom people who wanted to say something about this great bill, but I know everybody's really, really, really tired of being here.
What's the number on the bill?
It is Senate Bill 324. It's great.
All right.
My colleague to my left
Is
says
there
it's
anyone
great.
who wishes to speak either in favor of or in opposition to this bill?
If you're in the Zoom room and would like to speak in favor of this bill, please raise your hand electronically now.
No. You'll be surprised. Megan Ryan, Coalition for Open Government, and I wanted to rise to speak to thank the senator for taking our concerns seriously. The previous version of this bill changed the definition of public records in FOIA, and that about scared the life out of me. And you did fix that, and we do continue to stress that many of FOIA's problems are the result of overcollection of data, but that if any of you decided to give to my organization, I'd keep it on the hush-hush.
See? She cares about privacy. Data privacy. We started with all right.
You have a speaker online.
Mr. Chair, there's a speaker online.
Finance, okay.
Jerry Kilgore, please unmute and begin your testimony
I
now.
thought we had Jerry Kilgore on the line.
Yeah, thank you so much. I apologize for not being there in person, Mr. Chairman.
Sure.
I'm supportive of the legislation. I represent the People United for Privacy, which is a broad-based coalition of left and right organizations that support this very important legislation to protect donor privacy. Thank you for allowing me to speak remotely.
Certainly. Thank you for speaking. All right. We have a motion to report and re-refer to finance. If there's no further discussion, we'll vote on the board.
Senator Bell, how do you vote?
Aye.
14 ayes, 0 nays, 1 abstention.
I don't know. It wasn't on my list, but. All right. Yeah. All right. Senator Mason, you have a bill? Yep.
This is Senate Bill 199. So this is the contents of a storage facility. I'll start by saying, in the other world of the question as to whether or not you put foreclosure notices in the newspaper, I'm adamantly yes until the internet's ubiquitous. But this is the content of a storage unit that the owner has been trying to ping you for an extended period of time saying, please pay your bill, please pay your bill, please pay your bill and come get your junk out of the storage facility. And so this is trying to offer them the opportunity to, when you've finally not done so and the contents of the storage unit are left, just give that owner the opportunity to sell it in public accessible website, not necessarily notice it in the newspaper. Now, you're going to hear the arguments about the newspapers struggling and needing the revenue. I don't think this is going to save it. But I want to note that in the newspapers that are in front of a paywall, so I couldn't find it. I had to ask for guidance, but it is in front of the paywall. You don't have to pay. There are varying degrees of how they notice this stuff. One of them speaks to where it is, where it's located, and then it says Unit H209, no name. Here it says Doreen Bartlett, there's a public name, Doreen Bartlett, F006, Kenneth Husted, H002. So in this one it says some names and the unit numbers. This one it does the same, but this one has several unit numbers that just says Unit CO65, E119, E035. So about half of them have no personally identifiable information, just tells you what unit number they're selling. These websites do have pictures of the junk, so you can take a picture of what, there are 2 in Williamsburg for sale right now on a public website. One of them's going for a whopping $10 because it looks like nothing to it. There's 6 pictures of the other, and there could be some gold bullion in there, Senator Ruff's favorite topic, and that's going for $330. So these websites at least show you what you have the chance to bid on. That's the bill, Mr. Chairman. Sorry for the delay.
All right. Is there anyone who wants to speak on this bill?
If you are in the Zoom room and would like to speak in favor of this bill, please raise your hand electronically now.
Mr. Chairman, question for the patron.
Oh, question for the patron. So.
Yes, sir.
A very simple one, having watched those wonderful shows where they bid on locker units. The newspapers that they would be required to print in, are those also online, or are they? Did that include only online newspapers, or does it have to be a print?
Mr. Chairman, Senator Bell, it at this point is required to be in print, but they are offered online in front of the paywall. So you do not have to be a subscriber to see them online, but they are in the print edition, and that's kind of the crux of our conversation, Mr. Chairman, Senator Bell.
Yeah, I didn't probably answer that question, Mr. Chairman, well. If I could just follow up real quick.
Maybe I didn't.
Yeah.
Yeah, no, I don't think I phrased it well. So if like there's a newspaper in my county that doesn't do a print, they only do online. Would that count in the current law or not?
Mr. Chairman, Senator Bell, I might ask some of the opponents to answer that for me. I think the WI Daily, which is Williamsburg Yorktown Daily, and is an online paper only, I believe that qualifies, but someone from the press team might disabuse me of that notion, but I believe that does qualify.
Yeah, I appreciate it, but I like where you're going with this. Thank you, Mr. Chairman. Thanks, patron.
Mr. Chair.
Yes, yes, Senator Kiggins.
I just had a question on the patron. I just was wondering if there was any thought put into just military communities and veterans. You know, sometimes people deploy and then they leave storage units and they're hard to get in touch with. And, you know, I know you are trying to properly give notice before you would sell the goods and that, but was that taken into account? And did you think through just maybe an exception for military or anything like that?
Mr. Chairman, Senator Kiggins, thank you. Great question. I live in a heavily military area, and there are portions of the contract, the military status is disclosed in the rental contract, and if the tenant's a member of the Uniformed Services, the SCRA Services Civil Relief Act prohibits the sale of an active duty service member's belonging in all 50 states. So that would violate that act. So thank you, ma'am, for reminding that.
Thank you.
All right.
Thank you,
Provide your testimony.
Thank you, Mr. Chairman. David Halleck on behalf of the Virginia Self-Storage Association. We appreciate Senator Mason putting this bill forward. I can tell you there are under current law, you have to notify the person by certified mail. We want the people to come pick up their stuff and pay their bill. We lose money at the end of the day, you know, on these auctions, and the property. We want to get the property back into useful service as quickly as possible. Right now, the person gets multiple notices. We call them, we send them certified mail, we email them, we send carrier pigeons, whatever is necessary to try and get them to come and pay their bill. And I can tell you that not a single person says, oh, I've ignored all those, but oh, I saw a classified ad in the paper, and so I'm going to go pay my bill now. So what we have here is an antiquated provision in the code that the state is mandating the private business to purchase an ad in a paper of general distribution in the area that has no effect, no practical effect or benefit. Some of the press association and others will say it's a last-ditch notice to the person, but it's not. Nobody sees these ads and then goes and pays. The purpose originally in the statute was for this to be a notice to the general public to bring customers to actually bid on the property. And that made some sense in the 1970s, 1980s. But in this internet world where most of these internet, and you all actually passed a bill 3 or 4 years ago which allows these auctions to be online rather than have to be in person. So it just makes sense now to remove this mandate in the code and allow the option. If a locality, if Farmville, where Senator Mason's from, if the Farmville Herald is the best option to try and get people to be interested, they will have that option and they can put it in. And in a lot of the rural areas, I imagine they still will do a classified ad. But this bill at least gives them the option to determine what's the practical and most effective way to notify the public of that, whether it's online or in person. Thank you, Mr. Chairman.
Thank you.
Jim Mertz, please unmute and begin your testimony now.
Mr. Chairman, members of the committee, my name is Jim Mertz. I'm Senior Vice President of the Peterson Companies in Fairfax, Virginia. I also serve as a member of the Board of Directors for the Virginia Self-Storage Association. I just concur with all the comments that were just said. Our main goal is to really get the space back so that we can release it. And the requirement that we post an ad in the local newspaper just prolongs the process, and would appreciate your support of the bill. Thank you.
Thank you.
Sherry Neal, please unmute and begin your testimony now.
Thank you. Good evening again. Mr. Chairman, members of the committee, Sherry Neal, Intergovernmental Affairs Manager, City of Portsmouth. Ran this by our treasurer's office, and we have no opposition to this bill, and they're in support. So thank you.
Heather Summers, please unmute and begin your testimony now. Heather Summers, if you're speaking, you are currently muted.
Hi, I'm sorry about that. Mr. Chairman, members of the committee, thank you for permitting me to testify today. My name is Heather Summers, and I am the Director of Operations for My Storage. We currently own and operate 7 facilities in Virginia, 5 of which are located in the Tidewater area, and the other 2 are located in the Mechanicsville area of Richmond. I also serve as a member of the Board of Directors for the Virginia Self-Storage Association and have worked in the self-industry for the last 19 years. I ask for you to support the Senate Bill 199, a bill to modernize the self-storage lien process in Virginia. I'd like to address 2 items. The first is just the elements required of the intent of storage lien advertisement in Virginia. The second is the cost associated with that advertisement. First, the advertisement requirement was never intended to provide notice to the tenant. Direct notice is provided multiple times to the tenant by way of email, phone calls, text messages, traditional mail. The advertisement originally was to inform potential bidders of the upcoming sale. The tenant's name doesn't even need to be printed. The required elements of the advertisement only include the fact that it's a public auction, the date, the time, and the location of the public auction, and the accepted form of payment. Clearly, the intent of this provision to advertise the sale, not to provide notice to the tenant. While we have no legal obligation to do so, we have heard of some self-storage owners voluntarily including the name in the advertisement, which is an individual business decision. However, even if the name is included, it's rarely that. Actually, I've never seen in my 19 years where it's actually prevented or notifying the tenant to prevent the sale. And then second, clearly the cost of the advertisements. I could go on and on, but at this point, I think most of this has been said. So I just ask for your support in this bill.
Thank you. We'll move on to the last speaker.
Lynn Sykes, please unmute and begin your testimony now.
Mr. Chairman, members of the committee, thank you for welcoming me and allowing me to testify today. My name is Lynn Sykes. I'm the president of the Virginia Self-Storage Association. I've been in the self-storage business for more than 20 years. I'm currently serve as the vice president of operations for Storage Asset Management, which manages over 455 properties throughout the United States, including 23 in Virginia, in the Tidewater area, in Lexington, Harrisonburg, Northern Virginia. So we kind of cover all areas. I, again, with everybody else, ask for your support of this Senate Bill 199. Heather already mentioned all of the issues regarding the Virginia advertisement requirement really was not for the actual tenant, but for auction bidders. But the second part of it that I would like to bring attention to is that the Service Members Civil Relief Act is a federal statute that makes it illegal for a storage owner to sell an active duty service member's belongings in all 50 states, including Virginia. The SCRA has a provision that specifically applies to a self-storage that can be found at 50 U.S.C. Section 3958, enforcement of storage liens. That provision makes it explicitly unlawful to sell any service member's belonging absent a court order. And in my 20 years, I haven't found anybody. I live in Hampton, Virginia. Heather lives in Virginia Beach. So we're used to this very heavily military presence, and not one of us knowingly would want to sell any service member's belongings for the obvious reasons. In practice, every self-storage owner, especially in areas with heavily military population, has a provision in their rental agreement that asks the prospective tenant to disclose their military statute or status. Even absent that disclosure, we will do a search through the Department of Defense's Manpower Data Center prior to any sale to ensure there's no question regarding the military status of any of our tenants that may be in the military and be delinquent on their unit. And failure to comply with that SCRA comes with both criminal and civil penalties and liabilities. So this bill, Senate Bill 199, would not impact any military members, as the SCRA already ensures their protection in all 50 states. Instead, the bill updates the advertising requirement to reflect 2022 realities, and I ask you for your support for it. Thank you again for permitting me to speak today, and I would be happy to answer any questions anybody might have.
Thank you. Thank you very much.
Lonnie Bickford, please unmute and begin your testimony now. Lonnie, if you're speaking, we cannot hear you currently. Please unmute.
Okay. Yeah, I think I got it. Mr. Chair and members of the committee, thank you for letting me testify today. My name is Lonnie Bickford. I'm the owner of Apple Tree Self-Storage. I've had 9 facilities for 25 years. I'm also the owner and CEO of StorageAuctions.com. We do auctions for probably about 100 facilities in Virginia and have for years now. This modernization of this part of the bill, my job is to get bidders to the auction. And if running a newspaper ad would get them there, that's what we would do. We've done advertisements in Facebook and with Google, but what we mainly do is just create a website that when people search for things like this, they can find it on our website. Last month, we had over 34 million page views on our website. We offer free to the storage facilities a place to do their public notice, and they put all the contents on there. The managers then put pictures of the units on, and they come and the bidders bid. And it makes it a much more efficient process. It's very common for us to have 200 viewers for a particular unit, where an online auction has the big crowd of the internet. A live auction, if it's a rainy day, you may get 3 or 4 guys there. You may get 2 and it not be a commercially reasonable sale. If the weather's bad, it just, we've all moved to an online presence, and the newspaper is just not the way to get this done. If it was, it's how my company at StorageAuctions.com would find bidders in Virginia. It's not how we do it. We do it with the internet, and I'd appreciate your support for this bill.
Thank you.
Thank you so much.
All right.
If there's anyone in the Zoom room who would like to speak in opposition to this bill, please raise your hand electronically now. There's not appear to be any at this time, Mr. Chair.
All right, the bill's before us.
I get the same amount of time. Good evening, Mr. Chairman, members of the committee. My name is Amy Perrin-Seibert, and I'm here on behalf of the Virginia Press Association, as nobody is surprised to see me here today. And we would like you to obviously keep these public notices in the paper. I think it's important to talk about how we do not have any objection at all to these self-storage places putting any more information out there in auction and auction websites. We totally understand and appreciate that, but what we think is this legal notice of the auction should be, and the people's items are being sold should still remain in the paper, and that's why we're here today to speak against this bill. We believe that there's actually a fundamental disagreement on the purpose of the legal notice. I would argue the final notice in the paper is in the code because it's in the state's interest to protect an individual's personal property from being sold, and this is the final notice that you get to have for that. I mean, we have to think about why this was in the code. I don't think it was there in the 80s to make sure that people could sell things in the auction. That's not why we're here today. So we put these things in for all different types of notices go in that third-party neutral location, which is a newspaper. It's not the industry that's selling the items. It's a third-party neutral thing, and that's what we do for all items. I think obviously we've heard a lot of arguments today that people don't read the newspaper anymore. I think I'd argue against that. We may not always read it in the hard paper form, but we certainly read it in the version of clips or online. And I think it's important to know that that is a place that people certainly still read the papers. And there's also a lot of communities in Virginia that don't have the luxury of only being able to do that online. There's a lot of communities that still have a paper newspaper that they rely on to get their news and to get their legal public notices. VPA also heard the call about the modernization. People talked about this for years here, and so we came, and actually Senator Boysko had a bill that required us to, when we put public legal notices in the paper, it goes in the paper, it goes online in front of the paywall, and it also goes into the virginiapublicnotice.com database, which is searchable by item and searchable by location, so you can find all the public notices. So there are 2 online locations already and in the paper. This bill would basically be the very first time that we're taking a public notice out of the paper and giving it to a private industry, and we think that sets a bad precedent. We hope that's not what we're going to do today. I think we also talked a lot about, and I know Senator Mason's joking a little bit about people's junk, but people are putting a lot of things in storage nowadays, and it could be people's, prized possessions. It could be things like their family had to go put someone in a nursing home and their things are there. I think it's important to think that this isn't only junk, it is people's individuals' private property, and what is the state's interest in doing that? And so I think I just would urge you to keep this in the paper and not take it and put it on these websites. Thank you.
Thank you.
Thank you, Mr. Chairman, members of the committee, Megan Ryan with the Coalition for Open Government. And the reason it's in the newspaper is because the state has an interest in protecting the public who may lose their property. the state wouldn't have an interest, as Ms. Seibert said, in making sure that self-storage companies or any other private company got customers. This is a final step, and it will potentially reach not only the delinquent occupant, but also that occupant's family or friends who are aware that, with or without name on the notice, that Bob or Mary or whoever has a unit at this place that is selling, that is having the auction. A newspaper reaches people across jurisdictions who would never think of going to a Storage Wars website. Facility owners are not being kept from getting their units back into circulation because you are still requiring notice of some sort. This bill doesn't take notice away. So there's no extra thing there. It ultimately comes down to cost, the cost of a newspaper ad, and a cost that can nonetheless be recouped in the final sale of that unit, and a cost that to us pales in comparison to the cost of someone who may lose their personal property, and that the state has been protecting for a number of years.
All right, thank you. All right, the bill is before us.
Move to report.
Second.
All right, we got a motion and a second to report. If there's no further discussion, we'll vote on the board.
Senator Bell, how do you vote?
Aye.
10 ayes, 4 nays, 1 abstention.
Thank you, Mr. Chairman, members of the committee.
All right. Anybody else down here who has a bill to present? Yeah, all right.
You.
Yeah. All right,
Hey, Mamie, you
Mamie.
have the chair. He has a bill. He's back in the seat of power again. PBI.
All right, you could do it from there, that's fine, so.
Senator Barker.
All right. Senate Bill 341 is a bill to address an issue that is a significant concern across the country now. It's trying to deal with online marketplaces where there's a lot of things. Do you have? Oh, we have a substitute? Okay. All right.
Motion on the substitute.
All right. Second.
Moved and seconded that the substitute be adopted. All those in favor, please say aye.
Aye.
Those opposed?
Okay, sure. All right, what this does is it tries to deal with things where there are potential for nefarious action being taken. There are a lot of individuals who will post things online to sell them and do those types of things. And in many instances, these are stolen property or property that is counterfeit in many instances as well. And it's certainly been a significant issue. And what this is doing is trying to require that the online marketplaces obtain and provide basic information on high volume third-party sellers, so that the products that would be sold that would still be sold there would be ones that would be most likely to not be counterfeit or stolen goods. With that, I will let individuals and entities provide testimonies on it.
If you would come forward with your testimony and briefly tell us why you are in support.
Yes, ma'am. Thank you, Madam Chair, members of the committee. Kate Baker on behalf of Virginia Retail Federation, and we really appreciate Senator Barker putting in Senate Bill 341. This is a strong consumer protection measure that we feel is very necessary, and we've got 2 members here with us that would like to explain the importance of it.
Okay.
If you are in the Zoom room and would like to speak in favor of this bill, please raise your hand electronically now.
Thank you, ma'am.
It's never work-related.
Chairman Barker and members of this committee, thank you for the can I go ahead?
Yes, go ahead.
Okay. Thank you for the opportunity to testify on 341. My name is Brooke Mueller, and I'm the Director of Government Relations and Public Affairs for Walmart for the Mid-Atlantic states. Walmart has made a large investment in Virginia. We are the largest private employer in the state with just over 48,000 associates, 149 stores, and 4 distribution centers. Additionally, Walmart supports many local Virginia businesses. In our fiscal year ending in 2021, we spent $2.7 billion with over 900 Virginia-based suppliers, supporting an additional 56,000 jobs in the Commonwealth. It is on behalf of these associates, our suppliers, sellers, and most importantly, our customers that I'm speaking on this bill today. It was approximately 10 years ago that I stood here and I asked the Virginia legislators to pioneer an e-Fairness Act. I think some of y'all were around back then. That would level the playing field between online and brick and mortar stores. At that time, online growth had outpaced modernizing our tax policy, and it took states across the U.S. to patchwork this legislation together. And I'll remind many here today that that still has not passed on the federal level, that it was all the states patchworking it that filled that gap. But I'm back today to raise awareness that online marketplaces have outpaced legislation to protect both the sellers and the consumers. I'm now asking you here today to level the playing field by creating a standard for all marketplaces. This is a common sense and practical policy to provide transparency for shoppers, ensure fairness for e-commerce marketplace sellers, and to curb the resale of counterfeit, fake, and stolen goods across the industry. SB 341 would provide that protection for Virginia consumers. I just would like to also do a side note. As of today, this legislation, just like e-fairness was patchwork, is being patchworked on the state level. It's been introduced in 23 states. 6 states are pending. It's passed the chambers in 5 states, including in the last 2 weeks. It passed the Pennsylvania House 201-0, and it passed the Georgia Senate chamber 51-0. This legislation, which this bill 341 matches up with all these other bills that are being passed in other states, would simply require online marketplaces to verify high-volume third-party sellers and then disclose basic information that every customer deserves to know. It applies to both new and unused merchandise. And I'm here to say today that Walmart is already doing this. We are not exempt from this legislation. And I can go into more specifics about what Walmart is doing, but at the end of the day, Walmart, we use our global trust and transparency team, and we acquire a lot of this documentation, plus some additional documentation from our different marketplace sellers on our website. There's no added red tape. This is basic information that is required, and the details are protecting legitimate small businesses. So I'm trying to save some time, so I'm cutting out some
Yes, could you
paragraphs.
wrap up your testimony, please?
But anyway, thank you so much for allowing me, and I'm happy to answer any questions.
Okay, thank you.
Ask a question, Madam Chair?
Yeah.
So I don't know who's the right person to ask about whether this matches up directly to the federal law.
That was gonna
But
be
you
my
just
question.
suggested that this matches up to all the other states, the 201. Does
So
it match
this
up to Arkansas's bill?
It does not. So
So
Arkansas's
Arkansas's bill is
is different. So the Virginia bill matches up to the federal bill. There are some nuances. Pennsylvania has a little bit of a nuance. There are some nuances that are in other states. And look, we're very supportive of federal legislation. If the federal bill passes, it would supersede all the state laws to match up across the states. But we've been trying across all of our states with my colleagues to keep these bills as matched to 5502, which is the federal bill, as we can.
Thank you, madam. Thank you, ma'am.
Yet the federal bill has not passed yet.
No.
Chairman, I have a question.
Senator Donovan.
Thank you, Madam Chairman. I'm just curious, is it necessary for the seller's material to be published publicly, or can it just be available upon request?
So there are some protections in there to help people, like if you are, you run a small business out of your home, but you would meet the qualifications of the number of sales for that information to be protected. We do ask on the Walmart website that you have a way, whether it's an email or a phone number, for a seller to be able to to contact you. And so on a Walmart website, we would have the marketplace name, and then we would have either a contact email or a phone number. But if it is your private residence, there's a way to go about where that's not listed.
But, Madam Chair,
Senator
is it
Donovan.
necessary? Why is it necessary to post to everybody instead of be able to present the information if a purchaser asks? Like
It's
why?
a trust and transparent, we do it for a trust and transparency issue. So if you have bought from one of our marketplace vendors on Walmart's website, you have a way to contact them directly if there's a problem. Now, you can return the items to Walmart, to a store, but it also just gives you, from a trust and transparency standpoint, a way to.
But it would, Madam Chairman, I'm sorry.
Senator
But
Donovan.
it would accomplish the goal by having it available upon request as well. Because I think one of the anxieties is somebody who sells on eBay, maybe it is in their home, maybe, and I just wonder if there's a necessity to make all of that be published. I get the transparency, but if it were available upon request, then the consumer would still have it, but the seller would be somewhat insulated.
Like an email, so it's a way to contact the seller. And so, on eBay, when you go to purchase something, you have the ability to contact the seller through the email app. On the Walmart.com website, I have the ability, if I buy through a marketplace vendor, to click and then to email the marketplace vendor, much like eBay already does. When you're on their app, you can, only because I buy a lot on eBay.
So that would be satisfactory, Madam Chairman, excuse me. Madam Chairman.
I don't want to speak for all of my colleagues, because this is obviously just not me, but I'm happy to have that conversation and take that offline.
Madam Chair.
Senator Hashmi.
Thank you, Madam Chair. Just a question, and I asked this to folks who were speaking with me this morning, and I still don't have an answer to it. We can place regulations on marketplaces such as eBay, Walmart, and so forth, but the internet and the internet marketplace is just so amorphous and it changes fairly constantly. How do we regulate marketplaces that are outside of Virginia, that are outside of the United States? I have made purchases from online shopping retailers from the UK, from the Middle East, from Pakistan. How would this affect in any way the kind of disparate marketplaces that we really do have on the internet?
Well, obviously, we can't control what's not under our purview to control, but I wouldn't say the perfect should be the enemy of the good. Whether it comes to tax policy or regulation, given the amount of consumers, and I'm happy to provide you with some data that shop every day on what I would say are the big entities covered under this bill: Walmart, Amazon, eBay, Google, the list of the very large kind of marketplaces that are existing. You do have in your purview to start regulating those which you think would be best practices, if that's something that you feel fit. And I think that goes at getting at the problem, at least for, I don't know how many. I've bought a little bit of stuff from overseas, but I traditionally try to buy from what I think are U.S.-based organizations that I have trust in, that I have an ability to have a recourse should the item not arrive and be to my satisfaction. So we're just asking to create a baseline standard for what that looks like here in the U.S.
Okay, can we go on to the next speaker?
Thank you. Thank you all so much.
Thank you, and good evening, everyone. Chairman Barker. My name is Brian Gambarini. I'm the Senior Manager of State and Local Government Relations for the Home Depot here in Virginia. I'm a member of the Commonwealth as well. I live with my family up in Alexandria in the Fairfax County section. On behalf of over 8,700 associates across the state of Virginia, I'm here today to voice support of SB 341, bill establishing requirements for third-party high-volume sellers. Organized retail crime is a $69 billion industry that puts Home Depot associates in harm's way, leave consumers at risk of unknowingly buying potentially unsafe and tampered goods, and undermines legitimate businesses by forcing them to compete against deceptively cheap products. As criminals become more brazen, the threats to Home Depot associates and customers has increased. With the recent rash of smash and grab incidents that has drawn attention across the country, organized retail crime is a long-term problem for retailers like the Home Depot and businesses across Virginia of all sizes. SB 341 gets at the incentive of organized retail crime, the ability to sell stolen and counterfeit products easily and quickly and anonymously online. Under SB 341, high-volume sellers are asked to provide 6 basic pieces of information that any legitimate business would be willing to share. The information would be verified by the online marketplaces, some of the most technologically advanced companies in the world. These dominant online marketplaces must protect consumers from bad actors seeking to defraud consumers into believing their products are legitimate and, most importantly, safe. SB 341 is setting a basic seller standard to ensure legitimate businesses can use the internet to reach their customers around the globe and bad actors can be identified and stopped. I understand and respect that law enforcement resources across the Commonwealth are already stretched thin. They need the tools and resources to investigate, track, and prosecute organized criminal activity that targets Main Street stores and unsuspecting consumers across the Commonwealth. SB 341 pulls back the veil on illegitimate high-volume sellers, making it easier for law enforcement to differentiate between the good and bad actors. As Brooks said, and from Walmart, over 20 states are considering similar legislation. While the federal solution would be ideal, Virginia has never known and can't wait for the U.S. Congress to act. Thank you all for your time this evening. I ask that you support SB 341. I'd be happy to take any questions.
Okay, are there others? Thank you. Are there others in support of SB 341?
Madam Chair, Jody Roth on behalf of Virginia Retail Federation, and I do have handouts from our member Walgreens in support of this bill and the problems that they've been incurring across the country with the smash and grabs and the stores in the West Coast that have been shut or completely shut and have been hemorrhaging about $50,000 a week, and they are still not able to open them, and because a lot of their items from those are going to these marketplaces, which presents a consumer protection when you get into name brand medicines that they're stealing from these stores such as CVS and Walgreens. So if I could just hand these out, and I'm sorry they weren't handed out earlier. Thank you.
Thank you. Those in opposition?
If there's anyone in the Zoom room who would like to speak in opposition, please raise your hand electronically now. There is one, Madam Chair.
Okay.
Excuse me, 2. Servando Esperanza, please unmute and begin your testimony now.
Mr. Chairman and members of the committee, my name is Servando Esparza, and I'm TechNet's Executive Director for the Southeast region. TechNet represents over 86 companies, including several online marketplaces, including Amazon, eBay, OfferUp, Facebook Marketplace, Google Shopping, just to name a few. I'm here in respectful opposition to Senate Bill 341. TechNet's concerns with the bill are that small businesses that sell their products online should not have to comply with varying regulatory regimes or different disclosure requirements in 50 different states. Other states are crafting measures, as was just discussed a bit ago, that look similar, but ultimately it leads to a patchwork of different state requirements for those sellers. This is why we believe that this issue must be addressed at the federal level. We would submit that the most impactful thing that the state can do is to ensure that law enforcement has the tools and resources necessary to pursue these criminals and prosecute them. There's existing examples of organized retail crime task forces in a number of states, including Illinois, Utah, Arizona, Florida, Connecticut. They've been pretty fruitful. They've recovered thousands of stolen goods from storage units, semi-trailers that are estimated to be worth millions of dollars. Another main issue with the bill is that this bill focuses on the sale of items through online marketplaces and not a holistic approach of targeting organized retail crime. I know that our TechNet members companies stand ready to be engaged with partners, as we have partnered in a number of these states where these task forces are included on here. And I know I echo some of the concerns that were raised and some of the questions about the posting of this information. And it has already been said that this bill does not match the Arkansas bill that's already been in place. So what we're looking at is a patchwork that could be coming. Happy to answer any questions.
Thank you. Next speaker.
Montana Williams, please unmute and begin your testimony now.
Good evening, Madam Chair, Chair Barker, and members of the committee. My name is Montana Williams, and I'm the Director of State and Local Public Policy with the Chamber of Progress, a tech industry coalition promoting technology's progressive future. Our organization works to ensure that all Americans benefit from technological leaps. Our corporate partners include Amazon, Google, and Meta, but our partner companies don't have a vote or veto over our positions. We appreciate your commitment to combat organized crime, but we urge your committee to please oppose SB 341. First, SB 341 would make small online sellers collateral damage in Walmart's battle against Amazon. Brick and mortar marketplace giants are trying to stifle healthy competition and will ultimately hurt Etsy artisans, eBay sellers, and other online micro businesses. According to a recent article in The Atlantic, bills like SB 341 will ultimately help Walmart by weakening the competitive advantage of large-scale online shopping platforms. It won't stop sophisticated counterfeiters who will surely adapt to the new rules. Second, 15 state legislatures have rejected bills similar to SB 341, prioritizing the needs of online entrepreneurs and consumer choice. Legislators in both Republican and Democratic-led states agree this legislation would add additional obstacles that would ultimately hurt small sellers, decrease opportunity, increase red tape, and hinder consumers in search of a deal. The only state to pass this legislation is Walmart's home state, Arkansas. And finally, the version of the Federal Inform Act has already gained support from both retail groups, a coalition including Etsy and eBay, as well as Amazon. Online marketplaces are largely borderless and don't observe state-by-state boundaries. Passing this legislation would exacerbate a patchwork of state laws on an issue that is more properly addressed at the federal level. The consensus approach reflected in the federal version of the legislation represents the best model for tackling this issue without harming small online sellers. We hope you will heed the perspectives of legislators who have assessed the consequences of passing state versions of this legislation, and please oppose SB 341. The bill would take sides for Walmart against Amazon, would hurt small online business owners, and has been rejected in all but one state legislature. We encourage the Virginia legislature to instead support the improved federal compromise version of this legislation that has broader support. Thank you so much for your time, and I look forward to answering any questions you may have.
Madam Chairman.
Thank you. Senator Donovan.
What is the difference between this bill and the federal version?
Madam Chair, so this bill comports to the federal version. We have gone line by line to make it comport with the federal version. The only differences are two amendments that were done in Pennsylvania at the request of Amazon, and so we've included those in here as well to make it a little less burdensome on them. And they have endorsed this at the federal level. eBay, Etsy, all these lists that they were going through have all endorsed this at the federal level.
So, Madam Chair.
Senator Mason.
This substitute that we got this
Yes.
afternoon
This
is-
substitute, yes.
Okay, because it's, okay, thank you.
Yes.
Yeah.
Senator Barker.
Just briefly, to follow up on the question from Senator Donovan and Senator Mason, this bill, I will put in an earlier draft of it. What is in the substitute is basically the federal bill. So those people who are saying they're opposed to this because they're supporting the federal bill, this is the federal bill. And what you're seeing is, with some of the states that have had action recently on it, them passing with overwhelming majorities this legislation, and so it's as long as other states keep building on it, it's not going to be the patchwork that some people were afraid of. And it's not just an Arkansas bill. It's actually different from, in some respects, from what Arkansas had done. And so the approach is being responsive and trying to cut down on crime and the damage to businesses, both brick and mortar and online. So.
Okay. Madam Chairman, we have a real problem in this country. This is the first attempt to get it straight, and we need to pass this bill, and I so move.
Moved and seconded that Senate Bill 341 be reported. Does it have to go anywhere? No. Okay. All those in favor, please vote aye. Those opposed, no.
Senator Bell, how do you vote?
Abstain, Rule 36.
7 ayes, 3 nays, 5 abstentions.
Okay.
That's a lot of color.
Wow.
Madam Chair.
Oh, am I still the chair?
Yeah, you're still the chair, yeah. So.
Yes, Senator Barker.
Do we have a substitute for 764? Okay. All right.
Senate Bill 764.
The other bill that we have is 764. And,
Move the line amendment.
yeah. And,
It's been moved and seconded that we adopt a line amendment. All those in favor, please say aye.
all right.
Those opposed?
All right. Could staff discuss what the line amendment does?
Thank you, Mr. Chairman. The line amendment for Senate Bill 764, on line 163 of the introduced version, after the word report, strike the Chief Information Officer as described in Section 2.2-2005. On line 167, after to the, strike the remainder of line 167 through the word officer on line 168, and insert Virginia Fusion Intelligence Center. On line 168, after discovered, insert the Virginia Fusion Intelligence Center shall share such reports with the Chief Information Officer as described in Section 2.2-2005 or his designee at the Virginia Information Technologies Agency promptly upon receipt. And the last line amendment here is a second enactment clause that the Chief Information Officer of the Commonwealth shall convene a work group to include representatives from the Virginia Data Advisory Commission, the Office of Data Governance and Analytics, the Virginia State Police, Virginia Department of Emergency Management, Virginia Information Technologies Agency, Virginia Municipal League, Virginia Association of Counties, and other relevant state or local entities, and shall review current cybersecurity reporting and information sharing practices and make recommendations on best practices for the reporting of cybersecurity incidents, as well as the scope and implementation of the required incident reporting. If further legislative changes are recommended, work group shall report on its findings and such recommendations to the governor and the chairman of the Senate and House General Laws Committees by November 15th, 2022.
All right.
Would you read
Basically, what this bill does is it deals with cybersecurity and the hacks and those types of things, so which we experienced just recently as we were preparing for our legislative session. And what it does is originally the way the bill had been drafted to work with VITA on this, the intent was to have every public body report to the Chief Information Officer on these types of things when there's something that could be done or something that has been done nefariously, and to put it at the Virginia Fusion Intelligence Center run by the State Police. So we have it there, and then they will then communicate back to the Chief Intelligence Officer, Chief Information Officer, and be able to take it from there.
Okay. Are there any questions with regard to Senate Bill 764 as amended?
Move to report as amended.
I do have someone who may.
Oh, sorry.
Just briefly.
Is there any opposition to Senate Bill 764?
He was here last week too.
This gentleman has been here to the last bill 2 weeks in a row.
Yes.
I move to take his bill first next week.
This is my last one, Senator.
All right.
Always helpful, right?
So just briefly.
Madam Chair, members of the committee, thank you. I'm Joshua Hesslinger from the Virginia IT Agency, VITA. Governor Youngkin's administration and VITA support this bill. We thank Senator Barker for carrying it. Recent events have certainly illustrated that cyber attacks affect everyone across all state branches and local government. This broadens the reporting requirement from just executive branch agencies to all state and local public bodies to enable coordination and assistance, which VITA has done, including with getting the Division of Legislative Automated Systems back up and running for this session, threat monitoring for school districts across the state, offering laptops to a small county impacted by ransomware during the pandemic when they were scarce. And whether we're talking about lawmaking or allocating grant funding, the data is important. Thank you. The line amendments just redirect the reporting. They still ensure that VITA gets the data and can help. Thank you.
Thank you. Losing votes by the minute.
Oh, sorry, Madam Chair. Jeremy Bennett with the Association of Counties. I just wanted to express our appreciation for the senator, the patron, and also for VITA for working with our risk insurers and addressing our concerns. We're okay with the bill now and appreciate that. So thank you very much for taking more of your time.
Thank you.
All right.
It's been moved and seconded that Senate Bill 764 be reported as amended. All those in favor, please vote aye. Those opposed, no.
Senator Bell, how do you vote?
Aye.
Is Kagan still here? 13 ayes, 0 nays, 1 abstention.
13 ayes, 0 nay, 1 abstention. That bill is reported.
All right.
Wow, Meg.
Does that complete the docket?
Madam Chair, I think that's it. So
Like a carnival.
We are done. Thank you.
all right.